Thank you. We will now be proceeding with the welcome address by Professor Dr. Sri Krishna Deva Rao Garu, Vice Chancellor, Nalsar University of Law. Sir.
Good morning to all of you. It's my pleasure to welcome all of you to this very important one-day conference on artificial intelligence, law and justice in India. Dr. BVR Mohan Reddy Garu, founder, chairman and board member of CIENT, former chairman of NASCOM, chairman of the board of governors of IIT Hyderabad and T-Hub, Dr. Rita Vashishta, member secretary, Law Commission of India, Srimati Rama Devi, Director Emerging Technologies, Government of Telangana, my colleagues, Dr. Ravi Srinivas, other members of the Law Commission of India, and distinguished panelists. I think this is wonderful to see all of you here today. And just before this, we had another memorable discussion last half an hour that I consider is one of the best thing we would like to carry from this one-day conference. Briefly, let me look at, and then I'll come back to what we visualize from this conference. We are grateful to the Law Commission of India for organizing this conference with NALSA. This part of the conference series organized by them on various aspects in AI law justice in India. I'm sure that the outcomes and outputs from these will impact use of AI in law and justice. My colleague Ravi always puts this a greater, larger question. I agree with him. What he says is, today the question is not of whether we will be using AI in law and justice. The question is how to use it in such a way that it upholds constitutional values, enhances efficiency in legal and judicial system, and makes them more accessible and accountable. I would not like to take much of your time, but I'll just briefly look at, firstly is always lawyers, law teachers, judges, legal fraternity. Always law is reactive in a positive sense. When look at technology, technology is proactive. And once the technology comes, then we will look at how do we control, monitor, supervise, and other. That's in that way I use law is judicial system is reactive. But this is an occasion where legal fraternity should be much, much more hyper proactive. That's the time has come. Time has come. Technology in law is very important. It is a multidisciplinary. Engineers, lawyers, industry, judiciary, all of us, we must come together and to learn and develop a multidisciplinary course. Briefly, I look at as somebody who has involved in the legal aid movement for more than 3 decades, mentored by Professor N.R. Madhav Menon, founder of the National Law School movement in India, way back in 1988. I look at how AI can help in resolving the disputes quick and faster. And also as a constitutional duty, dharma, to distribute justice to all marginalized. In the words of Justice V.R. Krishna here, the poorest of the poor, Daridra Narayanas. How AI can help, technology can help. The best point here, Rama Devi and Mohan Reddy Garu agrees with me. Currently, the government of Telangana is coming out with a land law policy. How AI, law students, technologies, industry can come together, resolve. Major disputes, we leave it to the court. In fact, when the draft is still under the discussion, we will hold one-day workshop on this. All of you must look at the draft. I was telling when the government was looking at, I said, along with whatever you want to do, but dispute resolution, necessary. You must have, earlier collector used to have the power. Now you create a dispute resolution mechanism, not conventional, modern technology, market-friendly oriented. That's what we have to learn. So I said this is, but of course, we also have applications like online mediation. Now look at Mediation Act has come up. 2023 Mediation Act. And now we need to have, and Consumer Protection Act 2019 has been amended. One full chapter is added in mediation. Lawyers, law schools must take the lead. We should have a online mediation center in the Nalsar campus with the help of lawyers, judges, industry, and we must resolve it. So some of the applications like online mediation, AI-based arbitration, use of bots in judicial administration are set to revolutionize the concept and practice of law and justice. Nalsar already has been working in this direction. Ravi is an example. He came 1.5 years ago with that idea, and he has already set up Center for AI Law and Justice, and he's working with the Center for Responsible AI at IIT Madras, particularly in developing course materials for offering training. Our work with the UNESCO also engages with some of these issues, and these are limited to India. And we are already in the process of setting up. We were just discussing, I think that's a great thing I would carry from today's discussion is when I was discussing with Mohan Reddy Garu, next year we are starting with a 3-year LLB in the city campus. And in the discussion, what emerged is, now look at a new law. What is that? Only for engineers. Only that say 3-year LLB in Nalsar will start next year. We are still in the process of discussion. Maybe IIT Hyderabad, Nalsar will come together, evolve a course like IIT Kharagpur is a model. The only IIT which started only for intellectual property and the basic degree is engineering. Similarly, why not next year? Only for engineers. We will look at, I think that's the thing. So I'll just leave briefly with last technology, law, humanity. Last month, Attorney General of India is here. Venkatramani is a scholar. And Attorney General in his address, as he focused on technology, law, and humanity, AI and other. So the intersection of technology, law, and humanity is rapidly evolving landscape that profoundly impacts our society. Technological advancements are reshaping every aspect of human life, from communication, transportation to healthcare and education. In the realm of law, these changes present both opportunities and challenges. For instance, artificial intelligence, machine learning can enhance legal research, streamline case management, improve access to justice. However, they also raise critical questions about privacy, security, and ethical use. The law must adopt to regulate emerging technologies, ensuring they serve the public good while safeguarding fundamental human rights. Moreover, the human element in equation is to enhance human well-being, promoting fairness, equality, and justice. For Nalsar, this conference is a great opportunity. We thank the Law Commission of India for this and look forward to working with them. But Nalsar's work in AI is part of our work on law, technology, and governance, and we are sure that we can work with the Law Commission of India on this broad theme also. Lastly, I extend my heartfelt thanks to all distinguished panelists and students, colleagues, and members of the legal fraternity in Hyderabad, and also that from the Hyderabad Telangana High Court, and these distinguished panelists. So I welcome all of you and thank you for joining for this important occasion. Your presence and support make events like this possible. Thank you.
I thank the Honorable Vice Chancellor, sir, for his wonderful welcome address, highlighting the importance of how Dharma can be achieved by artificial intelligence. Thank you very much. I now invite Srimati Rama Devi Lankagaru for the keynote address. She's the Director, Emerging Technologies, IT&C Department, Government of Telangana. Ma'am, please.
We also have IT law minister who himself is a lawyer. Yeah. Yes.
Well, respected Dr. Rita Vasishtha, Member Secretary, Law Commission of India. Am I audible? Yes, yes, come. Dr. BVR Mohan Reddy Garu, an eminent personality here, and Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsar University, tech leaders, legal fraternity, faculty, students, and my own colleague Anand Krishnan is here. So a very good morning to all of you. Well, in fact, a decade back, if you think, you cannot imagine this kind of event happening in a law university. A law university, talking about technology is something couldn't have imagined a decade back. But now technology, more specifically AI, is shaping every sector and including law. And I'm really happy to see that the legal fraternity has come forward to actually embrace this new technology, to embrace this new change, that's happening in the technology landscape. I'm also happy that this event is actually happening, just before our Global AI Summit, which is scheduled in the month of September 5th and 6th. It's actually, we made a presentation to our Honorable Minister, about the entire program. So we included healthcare, education, agriculture, and everything that you can think of in AI, but we missed out law. So he said, no, you include law. And today, law, there is a separate track for law, and we are curating the topics in consultation with the Nalsai University. And Anant is actually working on that. Well, Telangana state has been the first one to come out with a framework in AI, recognizing the potential that technology offers. We actually launched one framework, identifying 6 key pillars. Of course, data and compute, education and skilling, research and innovation. While we have put reasonably done well, implementing that framework. And today we can proudly say that the state is a pioneer in using AI technology, leveraging AI for solving social problems. And when I say this, social problems, you're working again in different domains such as agriculture is one area we have used extensively, the AI to help farmers in one particular project, which we work with World Economic Forum. The reason I'm sharing this is this could be replicated in the law domain as well. So the farmers' income has increased by about 20%, by using technologies. So these are the kind of, then there are other tools also that we're using for the forest department, for the mental wellness, for children who are consuming drugs and so on. So just last couple of months, we started focusing on the health domain, actually, and we had a meeting with the Honorable Justice Vinod Kumar Garu and his team, and to understand their pain points, actually, because I'm a technologist, and a policy maker also. So, but I do not understand the domain where this technology can really solve problems. So we had really a couple of meetings with the team, and he shared, Justice Vinod Kumar shared very interesting use cases. And all of us know, that huge number of backlogs in, of cases, and people are suffering. So he said, can the AI tool help us to sort of group all the related cases? And he cited an example, and we are working on that, which probably will launch during the summit. He said, for example, GHMC cases, where many people actually file these cases in land disputes.
Correct.
And there are thousands of cases lying there, What he said, can you actually group these using AI? Can you group these cases together? Say they pertain to a same act, and then broadly say if judgment has been delivered for similar cases, highlight that. So it helps the judge to dispose of all these cases as a bunch, that will save a lot of time for the judges, for the court, as well as, especially when you look at real estate. I really came across this state where a father, he bought a land, to actually for his daughter's marriage, and it got into disputes and he couldn't really sell it. So in such cases, can AI be used to dispose of, is what we are trying to do. So that particular solution. And he actually shared another interesting use case where he said, advocates go and, argue for a client, right? But client does not always go to the court to see how his or her advocate, is actually arguing, advocate. So he said, can you develop an AI tool that actually translates speech into text and text into a local language? And that particular thing is shared with the clients, who are actually engaging these advocates. This brings in transparency in the whole, process, he said. So that's another interesting. And the third one, he shared many, but I'm just sharing 3 of them. The other one he said is, as a judge, I get, before giving the final judgment, we get about 10 to around 20 pages of, related to each case. He said, can the AI tool summarize the entire thing in 1 or 2 pages? So that actually helps me to dispose of cases quickly. So that will help the larger, that reduce these, what you call pending cases also. So these are the kind of, problems that we are trying to solve for the state high court, and for the law professionals, again, most of you know that, Gen AI tool can help you in carrying out research, queries, and so on, in the legal domain. While so far, whatever use cases that I've mentioned helps the legal professionals or the judges, courts. But one use case that's very close to my heart is, as a common man or a woman, I would say, legal is a very complex domain for us. We don't understand really. I'm a technologist, by the way. So when it comes to legal, something that just doesn't get to our head, So can there be a tool where, if suppose somebody is subjected to some abuse, physical harassment or something, before she approaches a lawyer or a court, she can type that problem and that tool should be able to tell her the do's and don'ts, what are the activities, steps that she need to take. That'll really help her. The victim, it could be her or him, anybody. So she's empowered before she actually talks to a lawyer, so that what are the things that she can do and she cannot do. So that kind of tool will be really helpful for the citizens at large, is what we are looking at. Maybe in collaboration with Nal sir, with other tech leaders here, we can think of working on that. But again, while I was talking to Rohan, you're working on LLMs, right? But I'm not sure, do we need an LLM for the legal Indian justice system, because our laws are different. So probably, I understand it's not easy. It entails huge, cost and effort into that, but maybe we can also think on that. In fact, we are working with a startup called Hanuman, who are investing in this to develop a legal SLM, short language models is what we are looking at. Probably that's an area that we can, collaborate. Another, while these are all the potentials, the way that we can use potential of AI, problem solving of AI. But there is a downside to, all of us know, biases that creep in, and also hallucination is one of the biggest problem that we're looking at. And as legal people, you might be aware, one high court, in the US, a lawyer actually used, a reply from ChatGPT or a Gen AI tool about a precedence for a case, and it just gave some precedence and he submitted in the court and he was penalized for that. So hallucinations are there right now, but going forward, they could be, further come down. And apart from that, one of the biggest risks the World Economic Report cites is deepfakes, morphing videos, images, it could in fact skew the entire, parliament democratic process. And some of you may be knowing that all these AI companies, OpenAI, Meta, they actually signed an agreement in Paris, to actually prevent such happenings going forward, to bring down those, by whatever way that they can do. Well, I really appreciate the university, for organizing this wonderful event with sessions on AI, law, and justice, and and the implications of the technology. I hope these outcomes will be helpful for us to move forward. Well, to conclude, they say justice delayed is justice denied, right? AI has the potential to bring down that delay and speed up the justice system. So, but there is a greater role for the law fraternity, and I believe that your role, your commitment, and your contribution will shape the future of AI in law in India. So with these, I close. And finally, I would like to invite all of you to the Global AI Summit that we are organizing in the month of September 5th and 6th. And I thank the Nalsa University's Chairman Garu, Vice Chancellor Garu, for giving me this opportunity here to share our thoughts. Thank you all.
I thank Srimati Ramadevi Lanka Garu for your kind words. Nal sir will, as you said, justice delayed is justice denied, and Nal sir will always be open for ensuring we integrate AI with law and to make sure justice deserves to everybody in a faster manner without delays. Thank you, ma'am. Now I invite Honorable Dr. Rita Vasista Garu, Member Secretary, Law Commission of India, to address the gathering.
Mr. B.V. Mohan Reddy, Founder, Chairman, and Board Members, Saint, Professor Shri Krishna Deva Rao, Vice Chancellor, Nalsar, Hyderabad, Srimati Ramadevi, Lanka, Director, Emerging Technologies Department of ITENC, Government of Telangana, Professor Anand Paliwal and Professor D.P. Verma, Honorable Members of Law Commission, Mr. M. Karunanidhi, part-time member of Law Commission, other esteemed guests, academicians, participants, and students present here. A very good morning to all of you. As I come from Delhi, it is my bounden duty to say something about Hyderabad. Hyderabad has played a significant role in the development of law in India, from its unique legal system as a princely state under the Nizams to its integration into Indian Union, which contributed to the unification of India's political and legal framework. The establishment of the High Court in Hyderabad and prominent educational institutions like Nizam College, Osmania University's Faculty of Law, and NALSA have been pivotal, producing distinguished legal professionals and contributing to significant legal scholarship. Hyderabad is also renowned for its architectural beauty and vibrant cityscape. Iconic landmarks such as Charminar, Golconda Fort, and Chomala Palace showcase the city's historical grandeur and architectural brilliance. In addition to its historical and cultural significance, Hyderabad has emerged as a major hotspot for technology, particularly in the fields of artificial intelligence, cybersecurity, and information technology. The city's high-tech city and adjoining financial district are home to numerous global technology giants, including Microsoft, Google, Amazon, and Facebook, which have set up extensive operations and innovative centers. Hyderabad's proactive government policies, ability of skilled talent, and strong infrastructure have made it a preferred destination for tech setups and multinational corporations alike. The city hosts several technology events and conferencing, fostering a vibrant ecosystem for AI and cybersecurity research and development. This medley of historical richness, cultural diversity, and technological advancement positions Hyderabad as a significant center for legal, cultural, and economic activities in India, and hence an apt destination for our conference. Ladies and gentlemen, the theme of this conference, Artificial Intelligence, Law and Justice, is highly germane. The timing of this event is perfect, considering the swift progress in technology. It's crucial to delve deeply into all aspects of this subject. I am certain that the esteemed scholars and experts present here will significantly broaden our collective knowledge on the various extensive topics to be discussed. Dear friends, fully leveraging AI has become essential rather than optional at this juncture. Across the globe, significant advancements have been made. The USA, UK, France, Japan, and China have all released policy and strategy documents on AI. The EU has gone a step further by enacting legislation to regulate AI. Despite ongoing debates about the priority of regulating such a nascent technology, the necessity of coordinated efforts to lead in AI development is clear. The NITI Aayog's National Strategy for Artificial Intelligence highlights 5 areas, that is healthcare, agriculture, education, smart cities, and smart mobility, as most likely to benefit from the AI advancements for societal needs. In my opinion, it is imperative also to include law and access to justice in this list. Moreover, the legal sector's contribution to the development of ethical and responsible AI should not be overlooked. Ladies and gentlemen, AI, once a concept relegated to the realms of science fiction, is now an integral part of our everyday lives. From healthcare to finance, AI has revolutionized various sectors, and its transformative impact on the legal field is becoming increasingly evident. One of the most labor-intensive labor-intensive aspects of the legal practices research. AI-powered legal research platform can analyze vast amounts of legal data in a fraction of time that a human would do. These tools are natural language processing and machine learning to sift through case law, statutes, regulations, and legal opinions to provide relevant results. This not only speeds up the research process, but also increases accuracy by reducing the risk of human error. AI can assist in predicting case outcomes by analyzing historical data and identifying patterns. By evaluating factors such as previous rulings, judges' behavior, and case specifics, AI can provide probabilistic outcomes. This can aid lawyers in advising their clients on the likely success of litigation, thereby facilitating more informed decision making. Legal professionals spend considerable time drafting, reviewing, and managing documents. AI can automate routine tasks such as contract generation, due diligence, and compliance checks. Intelligent documents review system can flag discrepancies, highlight relevant clauses, and ensure that the documents adhere to legal standards. This not only enhances efficiency, but also allows lawyers to focus on more complex and strategic aspects of their work. In areas such as corporate law and compliance, AI can be used to detect fraudulent activities and manage risks. By analyzing financial transactions, communications, and other relevant data, AI can identify suspicious patterns and flag potential issues. This proactive approach can prevent legal violations and enhance regulatory compliance. One of the most promising aspects of AI in law is its potential to enhance access to justice. AI-powered chatbots and virtual legal assistants can provide legal information and guidance to individuals who cannot afford legal representation. These tools can help users understand their legal rights, draft basic legal documents, and navigate court procedures, thereby democratizing access to legal resources. AI can assist judges by providing data-driven insights and recommendations. While the final decision-making authority should always rest with the human judge, AI can help in analyzing precedents, assessing the consistency of rulings, and identifying potential biases. This can lead to more informed and equitable judicial decisions. I applaud the Indian judiciary for being at the forefront of AI adoption and leading this transformative effort. The modernization initiative began with the e-court project under the National E-Governance Plan, which sought to digitalize court processes and create a networked infrastructure. Today, the National Judicial Data Grid offers real-time updates on both pending and resolved cases. The Supreme Court has introduced SUPAS, that is Supreme Court Portal for Assistance in Courts Efficiency, an AI-powered portal designed to aid judges in case management and decision-making. Additionally, with support from IT Ministry, the Supreme Court has developed SUVAS, that is Supreme Court Vidik Anuvad software, an AI-driven translation tool capable of converting English language documents, orders, judgments into 10 regional languages. Several other countries are integrating AI into their judicial systems. In US, tools like Compass, that is Correctional Offender Management Profiling for alternative solutions, are used for data collection, risk assessment, and decision support, while chatbot offer public information. The UK's Justice Ministry introduced a digital case system in 2020 that incorporates AI into the judiciary. China's smart court system, which utilizes AI, reports a reduction in judges at average workloads by more than a third. The main issue is how extensively AI can be integrated into our judicial system, and it can replace human judgment. This raises valid concerns, as implementing AI in judiciary involves both opportunities and risks. For example, the AI tool Compass in US case of State versus Loomis produced biased results. While AI has courtroom potential, addressing biases from distorted metadata or incorrect information is crucial. Ladies and gentlemen, India is grappling with significant issues related to case backlog, as told by Madam Rama also, and judicial vacancies with more than 4.5 crore cases pending and a considerable shortfall of judges. High court and lower courts are operating with 30% and 22% fewer judges than their sanctioned strength relatively. In light of these challenges, AI offers a promising solution for speeding up the delivery of justice, and its integration into legal system is a welcome development. While the potential benefits of AI in law are substantial, we must also address the challenges and ethical considerations. Issues such as data privacy, algorithmic biases, and the transparency of AI systems need careful regulation. It is crucial to ensure that AI tools are used ethically and they augment rather than replace human judgment. A troubling issue at the intersection of AI and law is rise of deep fake technology. Concerns about deepfake affecting elections are growing as they can be used to damage political opponents and disrupt electoral processes. Additionally, deepfake have a gendered impact, contributing online violence against women, with research indicating that a large portion of deepfakes involves pornographic content targeting women. Several legal provisions offer both civil and criminal remedies for addressing deepfakes, such as Section 66D, 66E, 67, 67A, and 67B of the Information Technology Act 2000. The IT rules also mandate the removal of content that impersonates others and requires social media platform to quickly delete artificial morphed images upon notification. Non-compliance with these rules can result in a loss of safe harbor protection, which shields social media companies from regulatory liability for user-generated content on their platforms. Further, the Bharatiya Nyaya Sanhita 2023 contains provisions that can be applied to tackle cybercrimes involving deepfakes. Notable sections include Section 79, which addresses acts or statements intended to offend a woman's modesty, Section 356, which pertains to criminal defamation, and Section 196, which deals with incitement to communal hatred, among others. I appreciate the IT Ministry's forward-thinking efforts in addressing this issue beyond releasing several advisories that enforce compliance with the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. The Ministry has also put in place regulations designed to boost accountability for both creators and social media platforms. These measures are part of a broader initiative to tackle deepfakes and other IT-related challenges. Ladies and gentlemen, it is crucial to consider the ethical implications of using AI in decision-making beyond the courtroom. Integrating AI into the justice system requires a comprehensive legal, regulatory, and ethical framework to foster trust in these technologies. It is vital to implement AI carefully, emphasizing transparency, fairness, and accountability. Moreover, providing training for judges, lawyers, and public officials is essential to minimize potential risks associated with AI. Ethical questions about AI's core nature necessitate guidelines and international agreements to align its development and use with human values and mitigate risks. To address these concerns, the World Ethical Data Foundation, with 25,000 members from major tech companies like Meta, Google, and Samsung, has proposed a voluntary framework with 84 questions for developers to consider at the start of AI projects. In similar vein, Niti Aayog has outlined 7 principles for responsible AI. These principles include safety and stability, equality, inclusivity, non-determination, privacy and security, transparency, accountability, and the promotion and protection of positive human values. In this regard, I wholeheartedly praise the government's initiative. By recognizing and adopting the potential of these technologies, they have clearly shown the resolve to make India ready and equipped to emerge as a global leader. In conclusion, the scope of AI in the development of law and dispensation of justice is vast and promising. As we navigate this technological frontier, let us harness the power of AI to build a more just and equitable legal system for all. Ladies and gentlemen, I am thankful to Vice Chancellor Professor Rao for collaborating with us in organizing this event and hosting all of us here. I also express my heartfelt gratitude to the government of Telangana for so graciously declaring us state guests and making our stay so comfortable. I am certain that this conference will clearly showcase the immense possibilities of AI and encourage a thorough and constructive discussion making among all the participants. Thank you and Jai Hind.
So very well.
Thank you.
I thank Dr. Rita Vasishtha Garu for the wonderful address, highlighting the government's commitment, the Law Commission's commitment, and Government of Telangana's commitment also towards AI and law. We will now move on to the special address by Dr. BVR Mohan Reddy Garu, Founder, Chairman, and Board Member, SAINS, former Chairman, NASCOM, and Chairman of the Board of Governors of IIT Hyderabad and IIT Roorkee. Sir.
Please, please. So there's so many useful things.
If you not speak extempore like you will need short time.
But very confident.
Professor Krishna Deva Rao Garu, Srimati Rama Devi, Dr. Rita Vasishtha, Dr. Krishna Ravi Srinivas, other dignitaries who are here today. Ladies and gentlemen, my good young friends from Nalsar University, a very good morning to all of you. I have to make a disclosure that I'm not a lawyer in any way, but I get very worried about law. Jurisdictionally, I operate in 21 different countries across the world. I keep saying, God, I believe in him, but I never get to see him. But as far as the governance is concerned, you better behave, otherwise we have serious challenges. So we employ the best of lawyers to make sure we don't get into that situations, but they don't leave us. I just came out of one fighting the Department of Justice of United States government. We came out scratch-free, but it involved tens of millions of dollars of legal fees. So therefore, we are very, very concerned about law. Very law-abiding people we are. So that's the reason why we came out scratch-free. So what I'm going to do in the next 15 minutes of time that's been given to me is to talk about my experience as a technologist. And for 50 years, that's when I started my career. And this 50 years of technology experience thereafter got translated into industry and also into education. But I'll give you a broad brush of what I think you as legal professionals should be doing with technology. The world has changed, transformed quite dramatically over a period of last 50 years. Halls like this remind me my first rendezvous with computers. I was a student at IIT Kanpur in 1974. My first time that I went to a computer center. why am I so fascinated with large halls like this is the computer got housed in a room of this size. More interestingly, there used to be a water fountain outside the computer center, and the water used to dance all around. The first few days I was there in the computer center, I used to get more fascinated with the water fountain. Amazing architecture is what I used to think. Till somebody finally told me that water fountain was primarily for cooling the computer center. Not even computer center, cooling the computer. It was a water-cooled computer. It was an IBM 7044. What was it doing? Catering to the requirement of 3,000 students on the campus. But what is the power of that computer? None of you would believe me, maybe Ramadevi will, is that it is less than the power of what you have on your smartphones. So that's the transformation that we have seen in the last 50 years in terms of computing power. So that has been my journey. And what we see today, the transformation further, if you look at it, is that we all say we're in a digital world. Everything has become digitized. So what has driven this digitization? Certainly, I think one thing that comes to your mind is all about internet. The ability to communicate with each other, our ability to connect with each other, brought in this digital world to us. No denying at all that got further backed up with things like computers. We'll come to spend some time on that, communication capabilities. Or for that matter, the human ingenuity in terms of innovating new business models. I wouldn't have thought about doing an e-commerce as a business model 30 years back. It is human ingenuity which brought in this new business model called e-commerce. So therefore, it's a combination of, and what happens in technology is that collaboration between people certainly amplifies it. It's just not one person who does that. So actually there was a remark that was made sometime earlier. We need, therefore, a very strong collaboration between the judiciary and the technology to ensure that we also become much, much larger. So therefore, we're saying technology is accelerating at this point of time. And because of this collaboration, it's amplifying. If you ask me, is this, oh yeah, it's amplified, it's great. What do we see in future? It doesn't seem to stop at this point of time. So to me, there are 4 pillars I keep calling as the key for this technology to become all pervasive. Gallop at a speed never been experienced by mankind. So what are the 4 pillars? One is computers. They're becoming faster. 1976, the founder of Intel, Gordon Moore, made the statement saying that we will be in a position, I'll not quote the statement, but roughly what it means is for every 18 months, computers will become half the size, half the price, and double the speed. That's what Gordon Moore said. But what have we seen over a period of time? In 2010, people went back to revisit Gordon Moore's law. It's famous, very famously known as Moore's law. And people said, no, it's not true any longer. In 2010 onwards, the computers have become faster by 5 times. No, sorry, it's become faster by 2 times, the same thing as what Gordon Moore said, but it's just taking 6 months. It's not 18 months as what Gordon Moore said. And does it seem to stop at this point of time? No. People like me saw 4-bit processors, 8-bit processors, 16-bit processors, 32-bit processors. Then they said CPUs are no good. There's a new regime called the GPUs that came, and I'm sure you must be hearing about them. The famous company called NVIDIA, which brought them. And now they're saying, no, it's not GPUs any longer, it's TPUs, tensile processing units, quantum computing. So therefore, please do not think that something has happened and we need to react to it. It'll continue to work on us. This flow will not stop. The second one, which is very interesting, is also communication. I'm sure in the West it was slightly different. But people like me, even 30 years back, waited for 7 long years to get the landline connected in my home after paying for the so-called 1,200 rupees or so it used to be in 30 years back. Tell me, if any one of you doesn't have a cell phone with you right now, please put up your hand. No one. Everybody has a line with them. Please be brave to tell me that you have 2 of them with you. Can you put up your hand? You have, yeah, thank you. Some people are very brave people. So, and some people are probably have got also technology going with them because they have 2 chips in the same system. So this has become another very new development. We're all connected now. The fact is that you have a phone means you're connecting together. Our societies have become different. The speed of communication has become different. We've heard about the new deployment that we are doing right now. We work very intensely on 5G technologies, 5G and 6G now. Is that the latency is less than 2 milliseconds. What does it mean to a common man? Is that in the COVID era, we talked about teleconsulting. Doctor on one side, patient on the other side, we talk to each other. But with 5G, it's become now telesurgery. I can have a digital twin of the patient on one side. On the other side, I have the patient, the real patient. I'm moving a stylus this side, the doctor, the surgeon. And the other side, robo is doing the job based on the instructions. Cauterization, which was not possible in the earlier days, it's now possible because it's less than 2 milliseconds. The patient doesn't bleed. But more interestingly, if you look at this concept of connecting with people, today there are 7.4 or 7.5 billion people across the world. Currently, about 5 billion of us are connected together. And if you look at the power of the network, it's actually, as we keep calling it as, it's the square of the number of nodes. You can experience it, very simple words. You have 2 friends, you get some amount of knowledge, right? You have 4 friends, it multiplies. You have 40 friends, you become 400 friends. Now it is 5 billion friends who are talking to each other. You might not talk to all of them. You can choose and talk to people who like. But interestingly, now it is not just you're talking to people, you're also talking to things. On the same network now, as in 2020, you have now 20 billion people and things together. So look at the power of the network, where it is. I can start my car right here before I go there. Might have a chauffeur, that's a different issue, but still I have an overriding. I can tell the driver what speed he has to limit himself. I can set it up on my phone. What is it doing? It's communicating at that point of time. I'm sitting here, my emails are being replied, the one-liners, scheduled by time. So therefore, the power of the network has grown. The third one, which is very interesting, the third pillar I keep saying, is all about the sensors. At one point of time, we used to say ugly-looking, bulky devices. What did they become? They also become smaller. They become nicer. And what do? They can actually do whatever we do as human beings, whatever we sense as human beings. The five senses God gave us, the same 5 are done by the sensors too. And what are they costing us? For a dime, I can get 10 of them. And they are doing a perfect job, whether it's vision, whether it is feel, it is hearing, it is testing, it is tasting, it is also smelling. You might ask me questions on what the applications are. I'll come a little later, but I'm a little worried now that I've been spending a little more time. Therefore, the fourth one, which I need to complete, is these sensors at this point of time are putting zillions of data across. And that data is the one which is now come to the fourth one. We are applying algorithms on them to make it artificial intelligence. That's how we are saying you put algorithms on top of it to derive meaning out of the data. That's artificially being derived. And that's artificial intelligence. Or that's how the machines learn from these zillions of data that are going on. So therefore, I like to conclude by saying these 4 pillars I talked about are still at great play. If I just want to conclude on one more point there on sensors, sensors are becoming much more intelligent. People now think there's so much of data that's coming in. Even in spite of having 5Gs and 6Gs, it's not going to be possible. In spite of what you have in a cloud, which is teraflops of data, gigaflops of data, it's not possible. So we want to put computing right in the sensor. So that's called edge computing. So there's an edge right there to make sure it makes up what is good data, bad data, and then sends it up to the cloud. So therefore, to give you a flavor, not to scare you, my audience today, how rapidly is this technology changing? How rapidly is this technology being developed at this point of time? Let me give you a few examples. The first time that AI got used in this world is for handwriting recognition. It was the second one was speech recognition. So if you look at this, and then the other side, we actually put it on x-axis as the time period it took. On the y-axis, if you look at it, on the human potential, when did they reach the human potential at any point of time? So if you look at these first two examples of handwriting and speech recognition, they started as the first one, as I said, somewhere in 1993, 1994. By the time they hit this number called 100% efficiency as a human being, they're as good at this point of time. Ramadevi was saying that we should use some of the speech recognition stuff. They're already there, perfected. Bahubhashik, for instance, we are in a position to get in Indian dialects from one language to the other language. It's an IIT Bombay across the number of IITs we are doing together. So therefore, it was taking 20 years. How many of you use ChatGPT? Very good, very impressive. But look at ChatGPT at this point of time. How long did it take to get to 100% efficiency in terms of comprehension? I think somebody gave this example, pardon me, I think Madam must have given this example. I get a 6-page letter. I just want to say, give me a summary in 6 lines. It does it for you, right? So which means that it's comprehending. It's exactly doing what the human beings can do. And how long did ChatGPT take to build those models? It just took 2 years. That's the speed at which technology is being developed. To give you a flavor of speed at which people are adopting it then, let's look at that part of it. That part of it, if you look at it, for 1 million users of ChatGPT, for ChatGPT to get to 1 million users, it took just 5 days. All of us are, I'm sure, great fans of Apple, so we think Apple was the best that, had a great innovation. Steve Jobs came and, roosted the world. Everybody went after Apple. But Apple took 74 days to get their first 1 million users. Or for that matter, Facebook, which I'm sure many of you use, took 10 months to get 1 million users. Then we go to the next step of saying, how much time did ChatGPT take to get 100 million users? They just took 5 months. Who is their competitor? I'm sure some of you use it, is TikTok. TikTok took 9 months. Or Instagram took 30 months. So I'm only giving you a flavor to say that, technology is also shrinking in size. We said from 20 years of speech recognition to 2 years of ChatGPT. We're also saying adoption by users is also rapidly changing. So therefore, but today, look at what's the usage of technology, is that today Google gets 8.7 billion queries every day from 4 billion, approximately 4 billion distinctive users. That's how people are using technology. And what will that result in is that if you look at the world at this point of time, how important is technology? I'm trying to drive that point. Pardon me, I'll stop in a minute. How important is technology? Is the 5 most valuable companies in this world in terms of market capitalization are tech companies. Microsoft, Apple, NVIDIA. Who else can it there? Google, and then it's Amazon. 13 out of the 17 top market capitalization companies are technology companies in the world. That is important. that important has technology become at this point of time. So, but what we see is as this technology gets deployed, there are very serious challenges that are coming, though these are technology marvels. Are posing challenges for us. I'll take an example of healthcare. Healthcare, for instance, there's a very famous IBM software called the Watson. They use it for oncology. Now, the issue that it does a phenomenal job, but it also, people have proved, can make mistakes. So therefore, the question that comes up is if you deploy AI and then it makes some recommendations, who is responsible for it? You need robust legal systems to address these issues. The other one, which is a very favorite of mine, is all about autonomous vehicles. Fun and games. People are saying cars can be driven without a driver. It is. But the question that comes up is who is responsible if there's an accident that happens? Is the guy who made the car, the guy who made the software, the guy who owns the car? More importantly, an ethical question that comes up, and I ask this question, the car right now is in autopilot mode. There's an old lady crossing the street from the left-hand side. There's a young kid crossing the street from the right-hand side. It has to go and hit one of them. And it has to decide who does it hit. There's no chance that it can avoid. So human beings have their own rationale, reasoning before they take that decision. Can the computer take that decision? So therefore, you need to work on a legal frameworks, which are extremely important. There's no denying, I think Tesla and Waymo are doing an amazing job in terms of automating them. But are these issues also to be addressed? The other challenges that we see is data privacy has become a big challenge in this data digital world. I have two publicly listed companies. Both are listed in Bombay Stock Exchange. And 10 days before we announce the results, which means people are aware that the results are being at this point of time consolidated. The cyber attacks on our websites go up by 100 times, 100 times from compared to normal days. So that is the privacy issue. We all can have hunky-dory about having digital world, but therefore we need to be addressing this issue of privacy. And so is the issue of having some of the decisions being made by AI. I'm very worried at this point of time because our selection process for fresh graduates is done by an AI algorithm. We run, I think it's AutoView or whatever it is called. And I'm not very comfortable, but then people say the results are very positive. So therefore, along with technology, it comes with the deployment, you'll also have challenges. So what we are saying is what you need to do to address these issues in years to come. The first and foremost, I'll strongly advocate to all my young friends, as well as the learned people here, is that we need to make our courses multidisciplinary. The legal system has to definitely get into areas like you need to learn, not necessarily you become the specialist, learn computer science, you need to learn ethics, you need to learn sociology. That becomes very, very important. I think that is very critical because if we want to have a holistic picture of people, that's what needs to be done. The second one is this change is constant. It won't be stagnant any longer at any point of time. Degrees that we earn at this point of time are momentary in nature to me. You need to be constant learners. So people have to become lifelong learners as opposed to saying, I have one degree and that's good enough for me. And the third one is that your soft skills have to improve. The soft skills in two ways, and with the traditional ones in terms of collaboration, communication, teamwork, that's very important in a world that we are in today. But equally important is the changes that are coming in, unless you start becoming more critical thinker in terms of addressing these issues of saying how, the question is how, why, and what. Unless those are addressed, then you will not be in a position to grow and address the issues that we have in the society. Lastly, learning is not going to be difficult because we all said we had go to a class, we need to have a teacher, and the teacher, depending upon the teacher's efficiency, we are in a position to do well or not do well. That's not longer true. Today, you can be online. You have so many facilities. Actually, you can go and learn 24/7. I keep telling people in all seriousness, there's nothing called boredom and waiting for people any longer for me in life. Somebody turns up late for the meeting and apologizes. I say, no, don't apologize to me. I didn't wait for you, very honestly so. I was doing something more useful than probably talking to you. And so is the case with you today, that you can learn from any time, anywhere. So therefore, the world is in front of my young friends. And I'm so glad that Nalsar is doing this conference on AI. It has such a strong impact in future years to come. I think we need to play the intersection of technology, law, and justice together to ensure that we will make sure the society will be a safe place. Thank you again. Thank you very much for giving me this opportunity. Thank you.
I thank Dr. Mohan Reddy Garu for the wonderful address, gathering experiences from your, tremendous experience in the industry as well, and the 4 pillars which are crucially identified. And I'm also happy to share that Nalsar University takes its sociology, ethics, and even technology-based laws electives very seriously for many years, and we've been doing excellently in them, contributing to the legal industry.
Very good. Thank you.
Thank you. I would now like to propose a vote of thanks for the gathering. As we conclude the inauguration or the inauguration session for this one-day conference of AI Law and Justice, I would like to extend deepest gratitude to all our distinguished guests, participants, students for being present here today. Your presence marks the beginning of a pivotal dialogue, as mentioned by our honorable speakers today, in technology and legal frameworks. We will now break for a short interval and reconvene after the tea break. And we will dive into much important sessions, beginning with a session on AI in law and justice, present and future, by our distinguished speakers from different areas in the industry. Thank you.
Sorry, it took a little longer.
But he'll be joining on that. No, Rajiv Mukundan is not there. We need a training meditation of that. Only at the number, only one. Starting में बात करते हैं ना. Thank you. Thank you. Thank you. Thank you. Yes. Yeah. 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 It's important. You see how that is last year. Yes. I don't know. One is from AP. But I maybe for the after my yeah. But what in the same year, I would have left it. He could come. And he was very possible. And not my question. He had just joined in the night. So I may not have met the case. Yeah. That's the same. This is pretty something interesting.
How is Mr. Rawat? Mr. Rawat. Shatrunjay Rawat.
We call him Shatrunjay.
I know him very well. He used to come to he used to come to our high court for taking interviews, for selecting some technical people. Generally, time will spill over in this type of conferences. We don't stick to time. So you are going to speak on which subject, ma'am? Deepfake.
Swati water.
This kind of cyber attack is also possible on AI machines. Then what happens? What happens then? It's trained to do one thing and it does one thing. I think you have seen that film Robo. Rajinikanth's film. The moment a chip is changed, it behaves erratic.
Actually, you can just can change here. You just press the escape here, and you can just go to the and हो जाएगा जो भी है. It should be all right. How can I put the URL on this? So can you mail it to this mail ID? I'll tell you the mail ID. Nalsar.ac. Passwords. Or else you can connect your WhatsApp directly to this. Kanish. Sir, you can mail to Nalsar classroom into the classroom. One second. Classroom 12 @nalsar.ac.
I also took a
Dear all, we'll shortly begin with the session, first session. Thank you, honorable guest speakers, various fraternity from the outside universities, Nalsar University, and students for joining for the first session. The first session is titled AI in Law and Justice in India, Present and Future. We begin this innovative talk with Mrs. Sri M. Karunanidhi, part-time member, Law Commission of India, addressing the honorable gathering.
A very good morning to one and all present here. I am a member, part-time Law Commission of India, as well actively practicing lawyer before the Honorable High Court, as well before the trial courts. I am not well versed in the technology. So definitely you may ask, sir, are you not using mobile phone? I am not using mobile phone, but I am using computer. Everyone is having one or two mobile phone in the name of mobile phone. Is it a mobile phone or computer? As a lawyer, I used to put questions. Please answer. Is it a mobile phone or computer? It is a computer. From food to entire lifestyle, not only in Bharat, as well across the world, there are changes. What is permanent, please? Any young lawyer or student, please tell me. I got my own doubt. What is permanent? What is permanent? Change, and change alone is the permanent. Today in the inaugural session, Honorable Speaker described in the earlier time having telephone or television in the home is a very, very prestigious one. Very, very prestigious one. Nowadays, in home, at least 2 or 3 televisions, and everyone in the home is having at least 2 mobile phone. That means we are carrying a computer with us. So there are many changes. The lawyers in India used to present our pleadings before the Honorable Court by writing in the papers. Thereafter, there is a change. Lawyers used to type it in a typewriting machine. Thereafter, computer era. So it simplifies lawyers' work. It simplifies lawyers' work. When I entered the legal profession as a lawyer in the year 1995, every lawyer in the courtroom used to have a diary. Every junior members of the bar used to have a notebook in their hand. When a senior members of the bar addressing before the court used to cite the judgments of the Honorable High Courts and the Honorable Supreme Court of India, so immediately we used to write the judgment. Now, no lawyer is having diary or notebook. What is the reason? Anybody knows? What is the reason? The search engine, we have got mobile phone. We used to search by search engine in Indian Qanun or in the leading law journals. We put one word, we have got thousands of judgment. We have got thousands of judgment. Whether it is sufficient enough, according to me, it is not sufficient. We have to go through the judgment. We have to read the entire judgment. Then only a lawyer will come to a conclusion whether that this judgment is applicable to the case on hand, whether it can be cited before the Honorable Court or not. And in Tamil, we used to say, Yetu Suraikai Karikku Udavadu. That means, if we draw a vegetable or fruit in a paper, we can't use it. Like the same, we are using machines in the name of artificial intelligence. In the name of artificial intelligence, we cannot use for all. No doubt, we have got 5 crores of cases pending across the country. More than 5 crores of cases across the country. What will be the better way? What will be the better way to reduce dependency? We cannot use artificial intelligence in all such cases. No doubt, changes are necessary, vital. We have to accept it. No doubt, I am not standing in the way. But the very, very major and vital part of a judiciary and a major portion of the judiciary and the role of a learned judge is appreciation of evidence. Either it is on the criminal side or in the civil side. Learned judge, after going through the entire evidence, both oral and documentary, learned judge has a conclusion to arrive at a right conclusion. In many provisions, the right conclusion has been coined. How to arrive at a right conclusion? This is a very, very big challenge for the judiciary. Learned judge has to go through the entire evidence. A particular witness come to the witness box, he will reproduce the statement which were given before the investigating officer. Verbatim, there is no evidence. The prosecutor will argue that as per the statement given before the police officer, that is the investigating officer, so and so witnesses have been examined by the prosecution, there is a witness, evidence. So relying on the evidence, you convict me. The defense lawyer will argue, no doubt, that has been the statement recorded by the investigating officer, verbatim reproduced. It is nothing but parrot-like evidence. So as per the decision of the Honorable Supreme Court and various High Court, the evidence is liable to be rejected. So what the learned judge will do? He has to go through the entire evidence, not only one evidence, and he has to go through the entire evidence. Thousands of pages will be there. Whether the appreciation of evidence, the major role played by the learned judge, can be replaced by artificial intelligence, that is by a machine, is a very, very big question. I am placing before the person concerned, that is who is well aware of the technologies. No doubt, I will not stand in the way of using artificial intelligence. Pleadings is very much necessary both in civil writ proceedings as well in criminal proceedings. So we are using computers. As Vice Chancellor, Honorable Vice Chancellor in the inaugural address and other people said, artificial intelligence is very much to be appreciated, we have to accept, no doubt at all. As a lawyer, I can say there are many cases of a similar nature. Like if there was no license to drive a vehicle, there was an accident and insurance claim was there, and there was no insurance also on the date of occurrence. The insurance was not in subsistence on the date of occurrence. So the learned trial judge, by using AI, can segregate the cases. So batch of cases can be identified by using artificial intelligence. Even in the writ court, even in the appellate side, cases can be identified by using artificial intelligence, segregation of cases. Once we segregated the cases, then we can group it, we can list the connected matters, and the group of cases can be disposed so quickly. But to arrive at a conclusion, artificial intelligence cannot replace humans, cannot replace, and as well for court management, to manage the case files, we can use artificial intelligence, and we can use artificial intelligence during investigation. As rightly pointed out earlier by the speaker, the writings, handwritings, signatures, and face can be identified by artificial intelligence. When I started from Madurai High Court to this program, there was a discussion between the senior members of the bar. I said, I have quoted a case where there was no eyewitness at all. Admittedly, there was no eyewitnesses. But I said as a prosecutor, there was an eyewitness. Oh, everyone was surprised. Mr. Karunanidhi, you know well, you were the prosecutor and you are a defense lawyer. This is the admitted case of the prosecution that there was no eyewitness. I said, there was a CCTV camera. There was a CCTV camera. It is like a man that has been captured. What had happened has been captured and that has been placed before the court. So these evidence can be compared as an eyewitness, So during investigation, in many cases, regular police could not identify the culprits. So the government, as well the Honorable High Courts and Supreme Court, transferred the cases to the special investigation team like CBI, CBCID and other special team. They can use the artificial intelligence to identify the culprits by using the technologies, no doubt. The only question is the independence of the judiciary is the important thing that cannot be compared, that can't be defeated. And mainly I want to focus is application of mind. The learned judge, when final report is before the learned judge, and when a civil pleadings are before the learned judge has to apply his judicial mind into the facts of the case. Anybody knows what is taking cognizance? Law students, anybody knows what is taking cognizance? Please raise your hands. Whether taking cognizance has been defined in the Code of Criminal Procedure 1973 or in the BNSS 2023. Please raise your hands. Whether taking cognizance has been defined. It has been defined. The what would amounts to taking cognizance? As soon as the learned judge is applying his judicial mind into the facts of the case, he is said to have taken cognizance of the offences. It has not been defined in the Code of Criminal Procedure 1973 or in BNSS 2023. So, when learned judge is taking cognizance of offences, that means not only at the time of taking cognizance on the final report, it also applicable when accused is produced for the first time. Very recently, the Honorable Supreme Court of India came down a couple of days back. The order of the Supreme Court of India has been violated. The contempt of court proceedings was initiated and notice was ordered as against the judicial officer as well to the investigating officer. So, at the time of taking a person into the judicial custody, Article 21 of the Constitution of India will come into play. So, my respectful submission before this August audience is whether this application of mind can be replaced by the artificial intelligence. At the time of making remand, that means taking a person's personal liberty, curtailing the person's personal liberty, taking a person to the police custody or into the judicial custody by virtue of section 167 subclass 1 CRPC is a very, very big role to be played by the learned judge. So in many cases that has been challenged before the court of law. In Nakiran Gopal case decided by the Honorable Madras High Court, suo motu revision was taken up. Learned magistrate rejected the remand and directed the accused to execute a bond. The learned judge of the Madras High Court took note of the same, took suo motu cognizance and decided the order of the learned magistrate was correct. So, in many areas, the subjective satisfaction of the learned magistrate is taken note of. The subjective satisfaction in many areas in the Code of Criminal Procedure, in the criminal trial are very much necessary at the time of remanding the accused, at the time of taking cognizance of offences, at the time of recording die-in declaration, and the executive magistrate when passing order on 106 proceedings. So the subjective satisfaction is very much necessary. Whether this subjective satisfaction of a learned judge can be replaced by artificial intelligence is a very, very big question. I am handing over this biggest challenge to my sister. With this, I conclude. If any doubts are there, I invite those doubts. I am ready to answer those questions. Thank you for having given me this nice opportunity.
Are there any questions posed to Mr. Karunanidhi? I see no questions. If there are any other questions, you can send to the compiler later. We'll forward it the questions. Thank you very much, sir. From the learned experience of your good self in the courts, you have posed a very excellent question to the audience and the wonderful speakers here. We now move on to the next speaker, Miss Kannandru. She's a senior lecturer at the Hague University of Applied Sciences in Legal Technology. Ma'am, please address the audience. Thank you so much for being present.
Just open it. You open it. इसको बड़ा किसका नहीं? ठीक है ना? नेक्स्ट करके स्क्रॉल ही करना पड़ेगा, कोई बात नहीं. गुड. Good afternoon, dignitaries on the dais and off the dais. I'm really, really grateful to be called by Nalsar University for this occasion, for this very important conversation. I got my phone because I have to make sure that I speak in the time that is given to me. This is a topic extremely close to my heart and also to my mind. Really keeps me up at night thinking about the society that we are going to be going towards. We are at the cusp of the revolution. It is at the starting point. And very nicely, the topic also asks me to talk about the present and the future. And I'm very excited to also understand from you what your thoughts are. It's a future that we are going to be collectively creating. And as we were also having this discussion in the morning, right, that there is only so much one person can know considering the amount of changes that are coming in the society around us. And collectively, we are just more intelligent. So I would really appreciate your questions and interaction. I believe I have about 20 minutes and then some Q&A. I'll try to be as much in the time as possible. And with that, I'm going to quickly introduce myself as well. I'm going to introduce myself because I wanted to tell you a little bit about the kind of questions that I'm looking at in my current capacity as a senior lecturer legal tech at the Hague University of Applied Science. So as my current role goes, I'm coordinating the AI and the law minor, which is where I'm teaching the EU AI Act, the GDPR, the Digital Services Act, Digital Markets Act, the cybersecurity regulation that is there. And it is a whole host of technology regulations that are coming, especially in the EU. Of course, I'm coordinating the cybersecurity minor from that perspective as well. My background is in innovation and entrepreneurship. So I've been 3 times founder in the space of legal tech and justice tech. I have done impact investing in legal tech, justice tech startups in Africa and MENA. I've worked closely with the UN agencies and worked across startups in different parts of the world, including policymakers and management consultants. So my area of kind of understanding of different disciplines and different sectors is now kind of leading me to how things are coming to a convergence. We were just talking briefly over the coffee break. And because of that, I'm able to see myself as part of conversations which are happening at the EU level, where we are working closely with the technology companies, with regulatory agencies in framing the right questions, and then collectively, as the honorable speaker in the first half mentioned, the multidisciplinary, interdisciplinary nature of finding solution. So I guess when the questions are framed in the right way, that is the first big challenge that we cross over. And then solution is something that we don't know as yet as to what it would be, considering how fast the technology is moving. So to give you a concrete example, there is something called the Ethical, Legal and Social Aspect Lab of the European Union, which is where you pitch for funding. And the consortium that I'm part of, out of several, one of them is along with the Erasmus University, as some of you may know, along with Google, Microsoft, police agencies, legal tech startups. We are looking at AI in public safety. So what does it mean? We have broken this down for now into 2 critical case studies, which we believe that it impacts and includes all of the relevant stakeholders. And the first one is use of AI in crowd management. So what that means is that when there are protests, and countries across the world are seeing that, how can the regulatory agencies use AI tools to see, that the protest takes place in as much safe way as possible, and that nobody gets harmed, and things kind of get, don't get escalate beyond a certain point. So indeed, it's a very fair use case of AI by the police / regulatory agencies. But on the other hand, the ethical and the social and the legal aspect is around the privacy and data protection. Till what extent can the police go in figuring out who was there, what was their profile? Can they go through their social media profiles, which they are anyway doing in a way? But what more can they have access to? What more they can't? How much anonymization should they use? And these are very tricky questions. Police, as we work with them, they just want answer almost today. They said, please let us know what we can do. As the legal fraternity, as the academic minds, we have to make sure we consider fully all of the relevant perspectives before we go into, this is what you can do and this is what you can't. So that is one case study I wanted to talk about. The second one that I'm part of, and sir briefly mentioned, and he handed me over a very challenging question to take forward. Perhaps, I don't know if it fully answers it or not, sir, but the second project that I'm part of, along with Amsterdam University and legal tech startups, is AI admissible evidence. And how evidence that is generated through AI can be interpreted by the court of law. What are the relevant legal provisions at the EU level? That's one dimension of it. Another dimension of it is indeed what would we make of AI generated decisions and AI generated results, and where can we have the right balance between human decision making, as in the decision of a judge, and the decision by the machine or the AI. And these are, again, very, very interesting, extremely interesting questions. And the last one is, as academics are here today, I should also mention, it is called a metacognition project, which we just won a grant for. And here, along with some universities in Eastern Europe and Northern Europe, we are going to be looking at how people learn to learn. So metacognitive skills. And since, if some of you are following Mustafa Suleyman, who's the founder of DeepMind, which is acquired by Google, he is working on this particular aspect of customized AI assistant. What would it mean for AI in education, where each student's learning journey can be created in a way that the machine meets, or the AI meets the student where he or she is at, and creating a learning, how can you say, level playing field for that. And for that, kind of going deeper into that research question, we have taken the example of misinformation, disinformation specifically, so that how people differentiate between truth and not truth. And that, again, in my opinion, is going to be a very key question that we are going to be confronted with in the times to come. So much of information that is going out there, we don't know what to trust anymore. And that will make, unfortunately, trust a very rare commodity as a society, because by default we'll distrust everything. And again, that's a very big societal question, really. But I'll kind of just pause there in terms of the kind of project that I'm involved in. I'm mentioning this as part of my introduction to also kind of bring out what are use cases and case studies around AI and law that are being discussed outside. Now, very briefly, I wanted to give a quick scan of, what are the technological changes that we've seen in the last few years? I would usually do this in an interactive way, ask people in the audience, but owing to the paucity of time, I'm just mentioning this all at one go. And this is by no means an exhaustive list. I'm mentioning this taking a couple of steps back just from the AI technology, because as again it was mentioned in the morning by the honorable speaker, that we are living in a technological revolution of sorts. It's not just that AI technology is suddenly now making everything different. AI technology is resting on the shoulders of so many technological changes that have taken place in the last few years, and simultaneous changes taking place technologically along with it as well. For example, as he was mentioning that earlier, just that handwriting recognition would take 20 years and OpenAI did it in 2 years. Why? Because the amount of data that became available online for free for OpenAI to scrape. Again, there are legal questions as to whether OpenAI should have just scraped the entire internet. Being a startup, they said, we'll just go ahead and do it first, and then rather than asking a permission, we'll ask for an apology later. Well, that's how things are moving forward. Another technology that made AI so powerful today is the cloud computing technology, because data was able to be stored in huge quantities and being available across the world. So again, that physical infrastructure that made it possible. And these innovations should not be looked at in silos. The fact that we are constantly sharing all of our information online on social media, the fact that we are all kind of subconsciously aware that our machines around us are reading our minds or listening to us constantly, the amount of data that is going out there is just going to make the AI models more and more intelligent. And I don't know, I have some slides to talk about what it could go to and the legal questions, the ethical questions that will emerge from there. Especially if you put AI in touch with, the quantum computing. For some of you who might be aware of quantum computing, you will know, I see some people shaking heads. For those who are not, very quickly, I will say, especially because EU has large amount of funding earmarked for research in quantum computing. Normal computer looks at a point as either a 0 or a 1. It's a binary. But quantum technology is a world of its own, right? Because you don't know if something is a wave or a particle. Basically, that would mean a point can be 0 and 1 at the same time. And that is, fantastic. And it's a huge leap change in a common parlance, and how it would translate into our day-to-day life is that the amount of computing power that will be available to do huge amount of calculations that computers today also cannot do will become possible. And imagine with that particular mind that is being created, what kind of intelligence the machine will come upon to have. So that is again something that we have to be mindful of, and we are going towards that, right? I've mentioned a few: biotech, edtech, fintech on the screen here. I mentioned them specifically because I do see the legal tech aspect missing in the amount of technology that is coming in other sectors. We need more legal tech. We need more AI is one thing, but generally better ways in which laws can be interpreted, laws can be accessed by people, and laws can be applied. So those are really critical areas. Considering the challenges, I'm going to go a little fast, but maybe I did not mention the first one, the data being the new oil and algorithm being an important player. Since it was touched upon by the earlier speaker, I'm not going to go into much detail with this. What is artificial intelligence at the end of the day? It's that the machines have intelligence like humans, simply put. I would love to also give you a pointer question as to what do you think is intelligence? How do you think human think? And if machine has to stimulate how a human brain works, how does a human brain work? And from there, you'll be able to see how the technology works. I think we need more and more law students appreciating technology because it's fascinating. It's something that we see all around us. I would love to have gone into details here, but I think it also makes sense for me to ask one question at least. In terms of what is a narrow AI and what is a strong AI. I'm not giving you the definitions at the moment, but I just want to know from your intuition, what do you think ChatGPT is? Do you think it is a narrow AI or do you think it is a strong AI? Yes. I see strong AI. Right. So you are a believer that it's a narrow AI, right? Okay, interesting. Right. Yes, very interesting. And again, there are different ways in which AI would learn. So supervised learning, unsupervised learning, reinforced learning, where machine would learn by itself. But again, okay, so you are saying it's a narrow AI. There were people who were saying strong AI. Maybe I should give it up on this one. See, the text here says that narrow/weak AI is good at specific tasks, and strong AI does a lot of things at the same time. If you see ChatGPT, right now we ask a prompt to it, we ask a question, and it just produces an answer. It could even be a prompt which will ask it to make an image or a PowerPoint presentation for those of you who are using ChatGPT 4 versus 3. But maybe I could also ask by show of hand, how many of you are using the paid version and how many are using a free version? Paid version, can you please raise your hand? Oh, okay. A couple of you. See, digital divide occurs at many levels in the society. And this is indeed a nuanced way in which divide occurs. What is your experience of 4 versus 3? Right. Exactly as you said, ChatGPT 4 is trained on a much larger data set, and therefore it is more intelligent, one could say. Also because, you can plug into the recent kind of different apps, even Bing, and you can get almost instantaneous result. 3 is trained on a data till November 2022, for example, and you can. Absolutely right. But even if with all of that intelligence, ChatGPT 4 is also a narrow/weak AI because it cannot wash our dishes, it cannot drive our cars, it cannot do so many other things. It is just responding to a certain text that we give, and it comes up with the result. I wanted to showcase the benefits and concerns of AI technology. If you see the positive of AI technology, is that advancement in healthcare that we talked about. It does a lot of automative/repetitive tasks. It does, hugely different insights from big data, customer experiences enhanced. So these are the positives that come out of the AI technology. But when you see the concerns, whatever you put in, it kind of reproduces. If the data is biased, the machine is also coming up with biased outputs. Privacy concern and data protection have been talked about. Concentration of power. Those who know AI will be at an advantage. Those who create AI will be at a much higher advantage, right? And those who own AI will be at a very different level altogether compared to those who do not have access to even the technology. So then we have to start thinking of the question of digital divide as well in the society, especially in the context of access to justice. I'm going to mention one more, and since even ChatGPT is narrow/weak AI, if you open the website of OpenAI, you will see that it is saying we are working towards artificial general intelligence. What is artificial general intelligence? AGI, as they call it, is going to be more intelligent to do several tasks at the same time. We'll be able to do, more customized tasks. So a whole plethora of things will be connected so that it will predict what you'll need even before you need it. And that is also kind of just a very small use case of what it is going to be. Again, that is not the fully formed version of AI. It's going to be even more sophisticated and go towards a sentient AI, and that will be a machine that will be cognizant of itself. So that it will be the progression to which this technology is going forward towards. I wanted to kind of check in quickly about what constitutes AI, but before that, the check-in of the time as well. So since I have a few minutes left, I'm just going to go right into the legal aspect of what this technology presents. Moving on, I'm sorry, I'm going to have to skip a lot, but I'll mention this particular slide specifically. If you see how large language models affect occupation and industry, a paper by Princeton University, UPenn, and New York University, you can look it up. The top 20 industries that LLMs are going to impact most. The first one, I don't know if you can see it clearly, is the legal services. So indeed, something that the people in the legal profession has to watch out for as to what is coming. There was a study by Stanford University in looking at research in comparing LLMs with lawyers. And if you see the average time per document taken by a senior lawyer, you see that it takes about 43 minutes. Junior lawyer, 56 minutes. ChatGPT 4 will take about 4 minutes. And actually, Palm 2 was much better with just 0.73 seconds. So this is how it kind of works at exponential pace, 99.97% reduction in cost over traditional methods. But LLMs also hallucinate. And another research that shows that the hallucination rate across the models, GPT 3.5 hallucinates the least. So, and Llama 2, for example, out of the models that were compared, was quite significant in hallucination. So when we talk about impact of AI on legal industry, and I'm going to have to conclude on this slide actually, although I have far more things to say. In a nutshell, a few things, right? One has to make sure that one adapts with the changes that are taking place in the legal, in technology. That would mean that using this technology, embracing it rather than shying away from it. The question, as Ravi sir was also kind of saying, it is no longer whether we should use technology or not, but how we should use it. One of the key areas where AI technology is coming in the law fraternity is document automation, which is where a lot of startups are coming. A lot of AI generated research. That is where also we see huge changes coming. A lot of reduction of time of lawyers and judges as well. Communication, internal and external. We talked about the case of translation happening through AI. And even the chat bots that could be created. Rama ma'am also talked about that. So communication is one. Legal prediction and analysis is a key area as well. So you will know what outcome a certain case might take, what would be the prediction rate of winning or losing a certain case, where the outcome finally will go towards. So that is another area. Making sure that people are made aware of the legal problem, even sometimes before they will experience it based on their history and behavior. So to that extent, the technology will have the information about us and about the clients as well. So what shall we do as legal professionals? What kind of upskilling that we would need? Those are really the kind of questions, especially at the law school level, we have to start considering. But then again, the question is whether AI will take away all the legal jobs or not. I have to say, in one hand, yes, it will take away the current jobs. It will take away the automotive and repetitive jobs, but it will also create large amount of new jobs in this space. That would mean that those who are able to have little understanding of technology will be at an advantage over those who do not have that. Also, in terms of people who are able to connect different dots, so multi-sectoral understanding, if you possess that, again, you will be at an advantage over those who will not kind of follow suit on that. People who are able to understand privacy, ethics, data protection, those legal jobs will also be in significant demands. So yes, changes are coming, and changes are coming extremely fast. Business model innovation is also another thing that has to happen along with tech innovation. So again, business skills or some sort of basic understanding of how world works. As lawyers, we are in a very nice position to have understanding of society, psychology, and so many things that people go through. And combining that with technology will be really a fascinating edge that lawyers will see themselves at. At the end of the day, we have huge amount of access to justice issues in the society. According to World Justice Project statistic, 5.1 billion people do not have access to justice or have multiple access to justice issues. So on one hand, it is this technology is presenting huge potential to creating a society for the better, in making sure that better level playing field is created for people who would otherwise not have access to certain opportunities or access to certain information. So indeed, it's a cusp of a fascinating time we are all in, and I really welcome all of your questions. And if any other information needed after the presentation as well, I'll be very happy to be contacted. So thank you so much.
Any questions can be directed after the lecture. Take the after lecture. Thank you very much for the wonderful delivery of Express Ma'am. I think it has wonderfully put us all in a position where we'll to grasp the basic ideas of the narrow artificial intelligence, strong artificial intelligence, and adding on to the legal side touched upon. I think that placed us in a wonderful position to grasp the entire idea. Thank you very much for your interest. We now have Dr. Daniel Matthew connecting with us online to deliver the address. He's an associate professor at National Law University, Delhi, and he's going to join us. Sir?
Thank you so much. Good afternoon to everyone. Just a quick check. I cannot present my PPT. It's asking me to be either made a co-host or a presenter.
Just a
before
second.
I
I'll
can
just
do so.
check some. Can you please check it now?
Yeah, perfect. Just a minute. I'll quickly present my slides. Let's take it off from there. Am I audible and are my slides
yes.
visible?
We can see your presentation.
Fantastic. Good afternoon to everyone present. I'll just quickly put on the timer. Right. It's fantastic to be here. Before I begin, let me take this opportunity to thank the Law Commission of India, NALSAR, in particular, Vice Chancellor Professor Rao, and coordinator for the program, Professor Srinivas, for this wonderful program. It's great to be here virtually among such fantastic set of scholars who are engaging on some very extremely pertinent topic. Till now, the learning has been immense. I'm sure it's going to be the same going forward to sort of see the key facets which lie at the intersection of law, AI, and justice. Before I begin, a caveat though, my primary training is in law. And as lawyers, one of the first lessons we learn is that of skepticism. So let me use that as my starting point, and in the next 12 to 15 minutes, articulate my thoughts on this topic. As I said, I mean, it was fantastic hearing the previous speaker on this, Dr. Kannan, on this. And let me just pick up from where she left off. The 2019 World Justice Project report, basically it put out its scale, the global access scale, access to justice deficit scale, which predicted roughly around 5.1 billion or 2/3 of the world population with unmet justice needs, right? These were basically because they faced obstacles in resolving their basic civil and criminal justice problems, or lacked the tools to protect these rights. Now, by December 2023, the same project concluded that access to justice had substantially worsened. And their conclusions were very disturbing. And I'll highlight just three given the relevance to the current context. One was that there is an increasing wealth-based inequality in the prevalence of legal problems, and that people living in poverty experience legal problems far more than rest of the population. Two, and this is on the access side, that there was a wealth-based disparity in access in virtually all of the surveyed countries. And finally, overall, they came to the conclusion that the supply of justice service had failed to keep up pace with the growing demands of justice solutions. And if you look around today, this is borne out with what we see, right? Increase in number of cases, the number of laws which are now in place, the increasing demand for justice, and at times justice at doorstep. All of these ideas are putting increasing pressure on justice administration. I think the most familiar case that all of us know is that of docket explosion. And therefore, there's a near constant talk that has emerged for improving efficiency of our existing system. And I think that's where the conversation of AI makes so much of sense, right? With the emergence of digital technologies such as automated decision-making systems, AI has ended up providing us with what might be called as a cleaner, but at times controversial solution, right? And it's often lawyers who are pushing the brunt as to what that controversy might be. Now, the result of this sort of availability is there's more and more integration of AI into various systems of justice administration. And at all points of time, this integration is being looked at from a five standpoint, right? A five idea standpoint: efficiency, accuracy, accessibility. But the idea is to reduce cost and improve outcomes. So just as a quick thing as to where we are at present when it comes to use of AI, right? Professor Rao in his address touched upon the potential that AI has to improve the efficiency of court proceedings. So in judicial work, AI streamlines legal works, automates document reviews, case management, helps in scheduling. As various speakers outlined, it has the ability to quickly analyze vast sets of legal of database, ensuring faster and more comprehensive research. Inside the courtroom, as such, AI enhances case management with tools like automated transcription, translation service, and predictive analysis, right? And the idea behind that is to reduce errors and improve accessibility. And this is particularly key for multilingual and diverse legal setting societies such as India. And therefore, countries like India, Singapore, UK, New Zealand, all of them have been pioneers in bringing AI into the courtroom. On the other side, if you look at lawyers, a risk outlook report of 2023, which was conducted by the Solicitors Regulation Authority in United Kingdom, revealed that some of the largest solicitor firms in UK are already heavily utilizing AI for this research. But what was interesting in this trend is now starting to move from large firms to medium and smaller firms, basically signaling that there is a certain mainstreaming of AI tools or adoption of AI tools within the legal landscape. Unfortunately, that kind of data still doesn't exist for India, apart from anecdotal, but nevertheless, this is a good sort of representative of what's happening around us. And so far as law firms and lawyers are concerned, AI helps in a whole range of tasks, right? From data synthesis to analysis, comprehensive legal research, contract drafting, M&A, diligence, etc. Right? And the whole idea there again is to free up time. You increase the efficiency, you reduce the cost, and therefore free up time for lawyers to sort of concentrate on more strategic work. And there are already examples of such AI tools currently in the market. A few were mentioned by Dr. Mohan in the morning. A couple of others are like Kira and Luminescence, which are being used by some of the top law firms in India. Globally, if you look, AI has been around for a while, right? As Dr. Kannan was suggesting in her presentation a minute ago. And that integration of AI in legal field, perhaps I think shot to prominence when in 2016, researchers from UCL and University of Sheffield sort of used an AI model to successfully predict verdicts in 79% of 584 cases which were before the European Court of Human Rights. And they successfully predicted the outcome. And similarly, we know of the kind of experiment that the Estonian Ministry of Justice undertook in 2019 to use AI in dispute resolution, where they sort of looked at small claims, less than, I think, 7,000 euros, and were successfully able to sort of adjudicate all of them. Many more examples were presented by Dr. Vashishta in her speech in the morning. I'm not going to outline that. They are in front of you in the slides that I have. But what is very, very clear is that AI now is an integral part of courtroom adjudication, which itself is a very integral part of justice dispensation. When we come to India, I think the poster child for this coming together, AI, law, and justice, is the e-court projects that is going on right now and is currently in its phase 3. So if you look at the Supreme Court's e-committee's vision document on digital courts, they basically have a couple of key goals. I'm just going to highlight two, which is relevant from the justice perspective, right? So on the one hand, the idea is to create a digital infrastructure. So things like digital registry, a comprehensive repository of case laws, all the way down to intelligent scheduling of cases, to interoperability between multiple systems, particularly the criminal justice system. to the other end of how do I use these systems, right? So you have e-filing, open digital hearings, virtual courts, etc. My colleagues who are practicing perhaps can add more on this and the sort of impact and how effective they are in their presentation. But the idea, of course, is but before I move to that, just as a quick idea, the fact that AI is being utilized in court adjudication in India, and I think the examples are starting to come up quite heavily. I think one example that all of us are familiar with is the 2023 March Punjab and Haryana High Court decision, in which it was acknowledged within the judgment that the High Court had used the Chat GPT while deciding a case for bail. Of course, it wasn't on the adjudicative front; it was on the assistive front. But it was basically, I think, the first instance where ChatGPT was used to decide a bail application. Right. Similarly, more recently in May 2024, the Manipur High Court again utilized ChatGPT and acknowledged so to conduct research before passing an order. In this case, it was about certain explanation, certain understanding of basic concept, right, which the court wasn't very clear on, and it wasn't very clearly articulated in the affidavit which was filed by the parties. But that's basically the present, right? And within the present, there are some concerns that are starting to emerge. Some of them are fairly well documented. Some of them are projected. One of the fairly well documented idea, and I think it was again referred by multiple speakers, including Madam Rama Devi in the morning session, is the idea of AI hallucination, right? And the problem of proliferation of untruths. The idea being that generative AI tools are starting to become potent source of misinformation, just because how quickly they can produce information that is seemingly or apparently credible when you have a look at it. But this seemingly credible is completely false. And unfortunately, the issue is we still haven't been able to integrate things like legal, basic ideas of legal, professional, ethical obligations, such as honesty and integrity within these tools. The bigger problem, I think, is on the other two ideas, which I like to pick up. One is on the simple idea of this concerns which is now arising from a tiered access to justice. And the fear is that with more sophistication of AI and its greater sort of, its accuracy, the continuing and unrelenting adoption of AI might lead to emergence of a two-tiered system. In fact, I'm very glad that Dr. Kannan took up that, and she asked this question to the entire audience. How many of you use ChatGPT 3, which is a free version, and the paid version? And I'm fairly certain not all of you raised your hands when it comes to ChatGPT 4. And that's precisely the idea here, right? The idea is as AI evolves, right, there is going to be a spectrum of availability. And on one hand, you have these low-grade, inferior AI-driven assistants, chatbots, and others, to all the way the specialized tools that we are starting to see already making an appearance in the market. And the question is, if you want value, if you want quality, you need to pay. And the question then we will have to ask ourselves is, who is able to pay for this, right? Will particularly the poor who are driven and particularly the economically marginalized, will they be in a position to pay for specialized legal AI? And if they are not, then when we run the risk of further widening the justice gap and doing exactly the opposite of what the AI was intended to serve, that is reduce and eliminate the existing inequalities in access to justice. Perhaps a broader danger lies in something that was getting mentioned earlier. And I think there is a need to really look at this, right? One of the categorical problems that comes up, and I think this is also in the language of AI and language that we are starting to see in this domain, right? One of the biggest problem is, or at least is seeming to come up, is the indiscriminate push for use of AI might run the real danger of abrogation of that fundamental human aspect of judging, right? So what I want to say is that the danger is not about the machine becoming a human. I mean, and that's what virtually all technologists argue. That idea is to get AI to mimic human. I don't think that's where the problem is. And I think that will be achieved. But the problem is about human becoming the machine. And that's where the issue is, right? Across the board, it is acknowledged that if justice is to be both to be done and to be seen as done, then justice requires a human touch, right? And this attaches both to the process and the outcome of judging. And let me just take a few minutes to articulate what I mean by this, right? Justice Sudarshan Menon was one of the first ones who articulated this idea to say, what do we mean when we say process of adjudication or process of justice dispensation? One of the ideas, and apart from everything that the judge brings to the table, right, the knowledge and everything else, what judge is essentially required to bring to the table is a notion of empathy, right? Judges should have, and it's often an idea that is taught at multiple levels, that when judging, there's a certain level of empathy you get to the adjudicative process, so that the parties feel that they have been heard. And multiple sets would tell you that there is a whole cathartic experience. Half the time when parties know that they have been heard, that's the end of that dispute, to the point where the parties are also clear that the judge has appreciated the impact that her decision would make on the people who are involved. And this is an aspect of judging, right? A non-human adjudicator might be able to mimic empathy, but might be unlikely to be able to exercise and convey genuine empathy and social intelligence. At least I'm not aware of it now. I am subject to correction, of course, by my friends from who join us today from the technology side. Similarly, judging is not simply about a random application of rules to a particular set of facts. In the process of judging, there is also a reflection of the values that our justice system prioritizes, right? And right from the start, and that's the point of legal education, there is an instilling of these in human adjudicators. How far would AI tools be imbued with these ideas or these values like compassion or a nuanced understanding of equity? And therefore, there is a categorical need and that's a process of adjudication. That examination of dispute and application of law is not a mechanical idea. It is done in categorical recognition of the dignity and humanity of the litigants and people who stand before justice, which I believe AI at this juncture, currently where it stands, might find it difficult to emulate. This is on the process side. But on the outcome side is where we see a lot of AI application, right? And the understanding is simple. Here's a set of facts, here's a law, that's your outcome, right? And we have to understand that justice dispensation, and now I'm only talking about the court adjudication. I'm sure others would talk about other facets of justice administration. Of course, judges are required to dispense an outcome, right? But often what judges are required to do is customized outcome, an individualized outcome. And this is something more than mere pattern deduction or rule-based rule application based on existing data sets, right? Instead, it calls for an exercise of discretion in a normative reason that a particular set of circumstances be either treated as exceptional, or should it be distinguished, or either treated as sort of regular, or should it be treated as exceptional and therefore be distinguished from the precedents, right? Another key role that justice administration often does is development of legal principles, right? And this requires the judge to choose between several equally plausible interpretations of the law to decide whether established rules needs to be departed from, needs to be updated, or needs to be continued. This requires a very conscious, reasoned, forward-looking decision-making on whether and how our legal jurisprudence have to evolve, particularly when we talk about justice and the notion of justice within a particular given society, right? Of course, one can argue and one can ask, are these issues at all something that we should be asking the AI to do? And if not, then where then is the limit? And I think that is the broader question that we need to work. Of course, there are other shortcomings which are considered to be systemic challenges within existing AI systems. It has already been alluded to in quite some detail. Let me just sort of quickly run through them. One, of course, is the black box problem coming, and therefore the idea of lack of transparency in AI system. The idea being the opacity, the complexity, the secrecy of the algorithmic processes ensures that the decisional rationale is often hidden, right? And this sort of further frustrates and leads to an allied problem of explainability. How do people understand? Now, the problem is, even where disclosures are made, there is a general lack of technical training, and the complexity means that judges, and forget about laypersons like us, even judges are not properly placed to interrogate these tools and to precisely explain why and how these tools have contributed to their finding and conclusion. This in turn may prevent any meaningful review of findings and conclusions. The second problem that we face is the bias in AI system, right? And I think there has been some talk about it. A standard idea of garbage in, garbage out, using poor quality data to train data set would result in perpetuating the poor results. I mean, in the sort of discrimination or bias that is already exists in the system. Dr. Vashishta talked about this in her presentation, so I will not report it, but I would like to highlight one place where this was found in India, which was the Delhi Police Crime Mapping Analytics and Predictive System, right? It was using historical data, and when it was evaluated for it, in the Status of Policing in India report 2019, it was found that the predictive software being driven by historical data eventually ended up encoding patterns of discriminatory police behavior against historically marginalized communities, like the Muslim community, the migrants, the non-literate people. The problem thus is that biased algorithms, unless we are very careful with it, can in turn lead to unfair sentencing, reinforce systemic discrimination, and perpetuate unjust practices. And the final idea, which I think Dr. Menon alluded to in his presentation, was the idea of privacy and secrecy of data. These AI tools requires massive set of data to be going in. In the legal context, that would mean court opinions, petitions, statutes, regulations, law reviews, etc. But every time such data is put into the system, there's the whole problem of personally identifiable sensitive information. And thus there's a deliberate need to talk about ensuring security and privacy of data. To conclude, I like to sort of just quickly put on table certain ideas that can be beginners, that can be a starting point for some thought. One is we strengthen transparency, how particularly in the court system, by adopting open technology, courts, data standards, etc., by adopting algorithmic transparency, and finally providing access to data and information on how the court functions. Insofar as accountability mechanisms are concerned, we clarify the principles on the basis of which responsibility will be affixed, and given the number of players on this, on who will the responsibility be affixed. And finally, to do an enormous trust building exercise, right? Partly because there is inadequate capacity to engage with it, particularly from the non-technology side, there is a definite need to invest in capacity building and training so that people can understand this better. And finally, we conduct regular audits to see how these systems are functioning, both internal, external, and audits by regulatory bodies. I will end by drawing your attention to the sort of portrait on the right-hand side that you see of this particular slide. This is the famed work of Wanderer Above the Sea of Fogg, right? Just imagine ourselves to be the figure, this lone figure standing on the precipice of an evolving landscape, right? For us, this evolving landscape would be law, justice, and AI, where all of these three converge. Like this wanderer, may I invite you to gaze into the fog, right? Uncertain yet unresolute. We too must confront the ambiguity and complexity that AI introduces into our legal system. We cannot deny using it, neither can we shun it away. But let's take up the lesson that this painting gives us. Namely, the painting symbolizes the search for clarity, a search for closure in a world where the contours of justice are increasingly become obscured. Just as the fog may lift to reveal a landscape with all its beauty and horrors, so can the thoughtful deliberation and ethical application of AI brings us closer to the constitutional vision, namely justice for all. I thank you all for your patient listening.
I thank Dr. Daniel Matthew for the wonderful lecture and the fine points mentioned about algorithm transparency and how the courts are also responsible in the sense of this artificial intelligence coming to the fore right now. And I think now would be the perfect time that we have the next speaker who is responsible for as a registrar of protocol and e-courts in Telangana State High Court. I invite T. Venkateswara Rao Garu to kindly address the audience, and I think it will be a perfect shift with the speaker since we already focused on the courts in the previous speaker. Thank you, sir.
Thank you, brother. Distinguished guests on the dais and off the dais, a very good afternoon. I'm T. Venkateswara Rao, Registrar Protocol, and also looking after the information technology in the High Court for the state of Telangana for the past 18 years. I also profusely thank at the outset Sri Krishnadeva Rao Garu, the Vice Chancellor, for giving me this opportunity to speak briefly about the High Court for the state of Telangana and the technological developments that are taking place in the High Court as regards computerization of the High Court and the district judiciary in the state of Telangana and also in the erstwhile state of Andhra Pradesh. Friends, as you are aware, and most of you might have seen, that in the decades past, technology is lean to courts and court system. Huge loads of case records and law journals were being carried to the courts by the learned advocates, assisted by their juniors or attendants or drivers for presenting before the courts. In the state of Telangana, before 1985 or before 1980s, there was little use of technology. In the sense, there's no use of technology at all so far as computerization is concerned. I have joined the High Court of Telangana, hitherto the High Court of Andhra Pradesh, in the year 1988 as Secretary to Honorable Judges of the High Court. Then we have seen only a typewriter being used by the secretaries or the other office staff for either typing the judgments or corresponding with the government departments or the district judiciary. Even the cause list, as you all know, a cause list is a list of cases being posted before the courts, be it in the High Court or in the district judiciary. In the High Court, there used to be a printing press located in the High Court premises itself, which was generating the cause list of the High Court, staying late night hours by using typesetting processes. And maybe in the early hours of the day, they used to complete the cause list for all the courts and then used to circulate to the bungalows of the honorable judges and advocates who have opted to receive the cause list on payment basis. This was in the year 1992. Suddenly, something has happened. There was some differences because that was a government of Andhra Pradesh department. Some differences have arisen between the printing press people and the High Court. So the then registrar of the High Court thought of an alternative, perfect alternative to the cause list generation. Immediately, we have discussed with National Informatics Center, which is a central government undertaking, which is looking after the technology assistance to all the government departments. Readily, the director of the NIC has agreed that we will definitely assist the High Court in preparing the cause list through computerization. For that, they have taken a minimum data from the High Court and with a small computer and a small software application, we have started generating the cause list on computer. Thereafter, in the year 2000, there was a shift from the existing small software application to a more advanced software application called Oracle application by capturing more number of data fields for either reporting purposes or for data analysis. Subsequently, we have pumped into the High Court various hardware devices like personal computers, printers, multifunctional devices, network systems, then uninterrupted power supplies, and internet, so on and so forth, keeping pace with the developments of the technology. In the year 2005, a big revolution has occurred whereby the Honorable Supreme Court of India has constituted a committee known as E-Committee with the main object of computerizing the entire judicial system in the country. It was headed by a retired High Court judge by name Justice Bharuka. The initial target of the Honorable E-Committee was to build up infrastructure, computer infrastructure, both in the high courts as well as in the district judiciary. The infrastructure initially included providing laptops and printers to the judicial officers. And since the staff of the judicial district courts and high courts are not that experts in use of technology, they have also provided technical assistance to train the existing manpower of the district judiciary and the high courts. That's how personal computers, network systems, uninterrupted power systems, so on and so forth have been supplied to the district courts as well as the high courts. So this is the first step, this is the first phase of the e-courts project, whereby infrastructure was built up for making the entire judicial system a computerized one. Then the second phase has come in 2018, whereunder software applications have been developed for use in the district judiciary as well as in the high courts. Then only few of the high courts were using software applications for either generating the cause list or for certain other judicial works in the high courts. But with the intervention of the Honorable E-Committee, a common case information system software has been developed, which is the core of the software application on the judicial side, such as capturing the data of the case, developing cause lists, and for other reporting purposes. The other peripheral software applications are directed to be developed by the either in-house team of the high courts or the team by providing sufficient funds to the high courts. That's how the high courts and the district judiciary have taken an initiative for using computerization or software applications for their day-to-day use. So far as the High Court for the state of Telangana is concerned, we have developed an official website of the High Court, wherein we are providing the judicial as well as the administrative information of the High Court. The judicial information comprehends the case status information, the cause list information, and the cause list information is being provided judge-wise, advocate-wise, so on and so forth. It also contains the recruitment information, tender notifications, the directory of the High Court, and the profiles of the honorable judges. And this has been developed with the assistance of NIC, and now it is under the process of a sea change. It also contains the judgments delivered in the cases. It also contains a search-based database wherein you can access the judgments judge-wise, date-wise, and advocate-wise. Daily orders are also being uploaded on the official website of the High Court for the use of the clients. Hitherto, the client was facing a great difficulty in knowing his case status. So he used to depend upon the clerk of the advocate, who used to either pay no heed to his request or he used to demand money for the information to be supplied. Now with the click of the button, anybody sitting in any place, any location in the globe can see his case status. And this is also equally for the district court case status also. Then recently, the High Court has introduced live streaming of the court's proceedings, starting with Court Hall number 1, that is Chief Justice's Court, Now, as of today, all the court halls in the High Court are the proceedings of the court halls of the High Court are being live streamed with a facility to have hybrid mode of hearing. Anybody sitting in any place in the world can address argument in the High Court or any court hall of the High Court by using the hybrid mode of hearing. Then we have also introduced e-filing of cases, initially in tax matters and for the government pleaders who are filing their cases. So it is mandatory for all the tax matters and cases being filed by the government pleaders to use the e-filing module. So also, we have introduced paperless courts in the High Court, starting with Court Hall number 1, that is Chief Justice's Court, and Court Hall number 2. And we are proposing to have more number of paperless courts in the High Court in the coming future. This will obviate the necessity of carrying huge loads of paper books, case records from the administrative sections to the court halls, and thus avoiding any loss of cases in transit. The most important aspect of the High Court's judicial process is digitization of the case records. Approximately 30 lakhs disposed of cases are available in the record room of the High Court, starting from the year 1956, and even before that, since it is a Nizam's court. So, as you all know, the difficulties of storing huge paper books or records, they are prone to damage due to aging, pests, rat cuts, then water, fire, etc. So to avoid all these difficulties, in the year 2017, the High Court has taken a decision to digitize all the disposal of records initially, also the pending cases. The task of digitizing the records has been given to a stockholding corporation, a government of King, and at present we have digitized about 12 lakh cases, and the work is in progress. So also, on the mandate of the Honorable E-Committee, the High Court is translating all its important judgments into Telugu language by using SOAS tool. SOAS tool is nothing but an artificial intelligence tool which automatically translates your English text into Telugu language. This is meant for the people who do not understand English, so that they can easily read the judgment in their own Telugu language. Apart from that, the Honorable E-Committee, in association with IIT Madras, is taking steps to introduce artificial intelligence in the judicial system, how best it can tap the advantages of artificial intelligence for use in the judicial system of the country. So far as added to this, the district judiciary has integrated the police system also with the judicial system of the Telangana state. This is called ICJS project. The information from the police station will be shared to the court, and vice versa, the information from the court will be shared to the police station. And now summons through e-summons process, so that it will obviate the necessity of manpower going to the locations. And this will be digitally tracked by use of videography also, so that tomorrow nobody can say that I haven't received any notice from the police department. We have also provided speech-to-text software application to the honorable judges of the High Court for dictating judgments whenever the stenographer is not available to the honorable judge, so that time can be saved. And we're also proposing to give this kind of a software to all the district judiciary also. So this is the present status of the High Court for the state of Telangana. For the future, we are expecting more support from artificial intelligence in the matter of initial scrutiny of the cases through computers so that manpower can be saved. The data entry of cases automatically into the system by picking up from the case record. Then connecting similar cases into batches so that they can be heard together and there will not be any conflict of judgments. So also in similar matters, there can be template judgments so that given the facts, the template judgment can be generated from the artificial intelligence tool. So also pleadings can be done or it can be made out from the artificial intelligence. We have various number of categories of cases so that given facts and the input from the user, it can generate the pleadings ready-made so that with minimum tweaking, it can be filed into the court with ease. So also AI can be used efficiently in the matter of posting of cases. It can search how many cases are posted before an honorable judge on a particular date, so that if the cases are more in number, it can automatically switch over the cases to a particular date where the cases are less in number. That's how the board of the judge can be minimum and it can be well managed. So all these things can be utilized for dispensing justice in a very efficient manner. And this is my submission to the experts in the field of artificial intelligence to ponder and give us suggestions or improvements so that the entire judicial system as a whole can be benefited. Thank you. Thank you very much for giving this opportunity.
I thank Mr. Venkateshwara Garu for putting forward the commitment of Telangana High Court for artificial intelligence and e-processing the entire court system. It's quite useful for all the fraternity and also the students who daily look at all the cases from us. We will next move on to Dr. Akansha Nathani. She's the assistant professor at the International Institute of Information Technology, Hyderabad. I have a small request to the speakers since we're almost running 40 minutes late. Just the note of the time thank you so much.
So I'm not a lawyer. So I teach students supposed to be so the idea is that do the legal methodologies. But what I want to do here is to provoke certain questions for the legal fraternity from the perspective as perspective. Now the idea is that we're supposed to talk about present and the future. I completely take 2-3 minutes to go into the past and discuss some case studies with you. That what has happened so far and why these delays in the past that we are discussing now become maybe more complex and complicated in the context of what has happened so far. So, we know that just highlighted that AI is being used in a lot of activities now, right from deciding what you see on your Facebook, what tab will come to pick you, and what's the way it's being used. So we know that's being used in transport management, it's being used if you're applying for the jobs online. So if you're applying for the jobs online or LinkedIn or somewhere else, the AI being used to sort your CV, for the robot surgeries, for the loan applications, like what is your credit score and everything, even the reliability of evidences in the code. Especially the migration asylum kind of services like verification of your travel documents and different forms of administration of justice and the processes. But what has happened so far? Like if we try to look at the of the case study, so AI started to use AI in the Canadian information process system. And within a few months, maybe they realized that the huge kind of the different kind of biases that are coming up that have been shown by the AI-driven system in highlighting that which application is fraud and which application is fair. Again, it happened. We have gone as our enterprises where AIs were being used for monitoring confidence, or to speak to the AI, and AI would tell me that yes, this person is a genuine person because he or she is speaking in the dialect, which is spoken in the area where this person is claiming to be from. Again, we look at prices that were noticed. It's an open, and both Google and LinkedIn have already accepted that they were showing the high paid jobs only to men, not to women. Because the data says that they were trained on so far only man had the prestigious high paid jobs, and the systems somehow started learning that men are better candidate in comparison to women when it comes for these high paid and high jobs. This case that came up is an MIT graduate. Have these applications now that you give your auto instructions, which infrastructure, or you give a headshot to this. Yeah, so she gave her this headshot to this AI-driven platform to convert it into a professional headshot so that she could post it on LinkedIn. So what she's an Asian, and what this platform does is to make her skin fair and the eyes blue, and all kind of biases to look like that you are a more professional than the others. There's a recent report, and because there's a shortage of time, so I'm not going to talk about it in detail, but please read this report that has come out from MIT Technological Review, which claims that in South Africa, this whole private surveillance mechanism is generating new digital apartheid. And that's a very, loaded term. If someone is using that, how the private companies have placed CCTV cameras all across Africa, and now they are determining what areas you can have access to and not have access to. So a report that has just recently been released. What happens in India also? So you should read this report also, where this Uber driver in Mumbai goes to Tirupati, shaves off his head to do his religious worship and all of that, comes back, and then the facial recognition system cannot recognize him anymore, and he's blocked, and it takes him more than 40 days to kind of get it unblocked from the system. His car is on EMI and all of that stuff. So huge life crisis that he gets into, because now the AI driven facial recognition system cannot recognize this person. Several other case studies that have come up, because for example, all of you said that you use ChatGPT. Just try getting the views of ChatGPT on, let's say, Israel-Palestine crisis, or Russia-Ukraine crisis, and you'll see what kind of biases that are feed into. Or just do the simple search and say that best doctors around me, for example, and you will see a specific bias that's being reflected because of those who have already existed in the digital landscape, and the data had been processed. So this is the context, but in this case, within this specific context, there are two specific things that we should talk about, right? Because we are sitting in Hyderabad, and there are things that are happening over here, along with the other parts of the country, along with, of course, in the other parts of the world, which is happening. A lot of us have been talking about the predictive policing here, the facial recognition system. So recently an RTI was filed, and in which Delhi police accepted that, yes, they are using facial recognition system. And what is the benchmark that they have set up is the 80% accuracy. So if your face is matching up to 80% to a potential, criminal or potential suspect, then you would be under the you would be placed under the scrutiny and the legal process and all of that. So and here we have to understand this whole facial recognition technology, specifically if they're based on CCTV and all. They would depend on light conditions, distance, angle of face, and a lot of other things, like how do you dress up and all of that. So that in several states of the US, it created huge bias problem, and of course marginalization of already marginalized communities in the system, in the criminal data sets. Another one that I briefly want to talk about is the Samagra Vedika system. How many of us are familiar about it? Can I have a quick head count? Okay, which is very interesting because for almost more than 5 years, the government of Telangana has been using this AI-driven platform, Samagra Vedika, in which what happens that they collect data sets from 30 different government services that are provided, and they create what they call is a 360-degree profile of a citizen in order to identify your eligibility. Now, where does it come from? Because all of us have a digital public, are part of digital public infrastructure. We have Aadhaar cards, but Aadhaar cards identify only your identity and not eligibility, because in different schemes you have different eligibility. So that, for example, you should not own a house, there should not be a regular job, there should not be ITR filed or something like that. So different eligibility for different schemes. For example, if you're applying for scholarships, your parents' income should be less than a specific given numbers and all. So what they do, that they take all of this data set and they try to match the data sets and try to make sense of your 360-degree profile, so that if you're claiming some fraud, you're becoming a fraud beneficiary of a system that can be stopped. Quite a wonderful idea, but what happens here is that all of us, and specifically in the lower middle income group, you have spellings of name, differently written, the different identity cards and services, your address written differently. So sometimes what happens is a false tagging that happens, that, oh, you own a vehicle. And if you own a vehicle, you kind of cannot have access to this facility. And there are number of fraud cases, number of such cases were then being reported where people were denied to access to right to food because the system started flagging them as the fraud beneficiary. The case goes to Supreme Court of India, and Supreme Court orders the manual verification of all the applicants who have been rejected to have any kind of service. And the latest data sets that we have so far is that when the manual verification is happening, and I think 1.8 million people have to be verified, and out of which they have done some 1.5 lakhs verification so far, as per the latest data that was available a few months ago. There's already a 7.5% error that has occurred. And we cannot forget that we are a country of 1.6 billion, 1.5 billion, where 1% means 1.5 lakh people. So these kind of challenges that are emerging because of the biases that exist in the data sets that are used to feed into this. And also, there's another important information, because it's a legal audience, and that I would like to highlight. So the RTIs were filed to know the source code to the data sets that are being used for the Samagra Vedika system, and the response that was given was that it doesn't come under RTI, because Samagra Vedika is a private corporation and it is not entitled to share that information with you. Whereas the Canadian case that I was talking about, when these huge discrepancies started coming, one of the decisions that the government of Canada then took is to make it public that what kind of data sets are you feeding into the system, and what kind of source codes have been written so that it reaches to a certain conclusion. So, but what is happening, presently, and I would like to place it into theoretical, like social science theoretical questions, from which, angle it all has to be set into. So all of us have been talking about EU AI Act from the very beginning, and of course it's a landmark in its own sense for attempt to regulate this whole AI-driven space. But before we talk about EU AI Act, we also have to see that there are three major different approaches that are emerging globally towards the question right from data ownership, which will lead into AI regulation. So if you see at the American approach, they will believe that whatever data, let's say you've generated on Google, it belongs to Google. So market owns your data, and whatever they do with this data, that's their business. Whereas if you look at the EU approach, it says that no, you individual is the primary owner of the data, and if you want to do anything with the individual's data, take consent, give information, take consent. So the primary owner of the data is individual in EU's case. Whereas if you see the China's case, everything belongs to the state. Okay, so if China, what they are doing, that they're already using these facial recognition technologies in social sorting of the citizens. So they track your behavior everywhere, and if you have been a good citizen, you get concession on the interest rates or something like that. So they have designed that kind of system, which EU has banned in the EU AI Act altogether, that you cannot do. So you will have to see that these are the three major approaches that are emerging. And if we are looking into the legal landscape of AI regulation in India, we first have to deal with this theoretical question that whose interests are primary for us, like what kind of model that we are designing. So But again, coming back to the EU AI Act, as India's and as the as it would be applicable for the people in the developing countries, is the concern on what kind of structural dependencies that are being created by the first world countries for us. So they make these laws, and then in order to do some kind of business with them, they just say that you have to have these kind of, let's say, legal frameworks, policy frameworks, technical frameworks into place in your own country, and then only the business happens. Otherwise, it does not happen. So the kind of structural dependencies that are created, like this is one of the research area that I do in terms of advocacy decisions and everything. But another theoretical concern that's emerging specifically in the developing nations is on the ex ante versus ex post regulations. That what do you do with it? Do you predict that what might go wrong and put policy frameworks in place in advance, or do you see what goes wrong and accordingly you kind of respond, which is essentially a debate between too much versus too little, like too much and too early versus too late. And too little. So I was reading this paper recently, and they use this very interesting term, which they said is awful but lawful. So it is the kind of things that are happening today. It might be a good idea to look it from that perspective. So this debate essentially can be placed, especially for the developing countries, as balancing innovation versus regulation, because this is the area, AI-driven technologies, which has huge potential, not just economically, but also at the social, at the democratic levels. But then at the same time, how do you balance innovation and regulations, within which there's a very popular thesis that has come across in social science, is the high stakes versus low stakes thesis, where they say that if the stakes are low, you can use AI. You do not owe any right to explanation. But if the stakes are higher, then there has to be some regulations in place and all. But a lot of research that is coming out now claims that even the low stake decisions, they form a pattern which would later on lead of aggregative decisions which are pretty high stake. So within this context, I have, and I would like to conclude with these few submissions, and I would rather call them provocations, because I'm sitting here in the legal fraternity, and I'm assuming that many of you would be part of Global AI Summit to take it forward. That how do we do it? So. First of all, I believe that all discussions that we are doing, we have to start looking at in the Indian context. And when I say Indian context, there are three specific things that we have to keep in mind. First, that we have to understand, and because we are calling them Global AI Summit, and I see as these global data governance frameworks when it comes to AI, they are highlighting certain advantages and certain challenges. Now, my submission here is that the anxieties and the excitement regarding AI advancement is different between Global North and Global South, and it has to be, those anxieties and the differences have to be located and dealt with. The another thing that we have to see, that the countries which are proposing these global frameworks, their population had access to computers before having access to phones. In India, the access to internet to people has primarily come via phone and not via computers. So the level of digital literacy or training or awareness, that's completely different here. Another thing that one has to see is, and Sir was talking about it before me, that you are digitizing the court records now. But primarily the AI advancement that is happening in India and the developing countries is on the born digital data, the data which was created digitally only, but not the digitization of the historical data sets that we already have, which the first world countries has already dealt with it. And third aspect is the digital public infrastructure that we have, which is very unique and not, unique to a great extent and not existing in the other countries of the world. So what do we do now? If we have to talk about future, I think my first proposition, and because nobody has talked about it so far, so I would really like to emphasize on it, is on the cost benefit analysis of the AI, deployment. So one part, of course, we have discussed is the constitutional values, the impact that it might have on the, let's say, rights of people and human rights and the other stuff. But the second second thing that we are skipping from this debate is the, hardware of AI. So we all of us think that AI is just a software and exists in the cloud computing and all of that. No, there is a hardware of AI, which is essentially the data centers, and the world's largest data centers are now being set up in Hyderabad in the other countries of the world. So these data centers have huge environmental costs. Now, what happens that the first world countries generally do not allow the data centers in their countries because they generate extreme amount of heat, and then you have to use a lot of energy, air conditioning to keep them cool. And for that, the cheapest way is to use the water, which is like you're using a lot of groundwater. Huge protest happening in Chile, Uruguay. Chile has already cancelled license to Google to build, data centers because it started creating water crisis happening in the other countries of the world. So we actually need to do the cost benefit analysis which the cost benefit analysis has to include the environmental angle into it. Then we definitely need to talk about the right to explanation. Whatever, when the decisions have a significant impact on your life, it should be able to, the algorithm should be able to explain why it took the decision that the decision it took, which right now is under the under the argument of black box and all of that stuff that we use to explain. But there has to be a constitutional or at least a legal framework for the right to explanation when it comes to use of AI. There has to be high quality data sets that has to be fed into the system. Of course, the clear and adequate information has to be given to the people. And there has to be high level of robustness, specifically in the Indian context. I repeat again, two things that we have to keep in mind. First is that globally there's a push on human in the loop, that you put human in the loop and then you fix the problem that AI is generating. But in the Indian context, because of the digital literacy and the other things that we might need frameworks for the institutional oversight as well. So there is recent scholarship that is emerging on these frameworks. And second, the first one is also only concerned about the privacy. We cannot just stop at privacy. We also need to take care of diversity, because the way algorithms work, that essentially is anti-diversity, so to say. So the diversity by design frameworks, not just privacy by design frameworks, that are really, really essential. So yes, I would like to add with the last sentence, and let's take the conversation further to the lunch, is that we also need to be careful about the new social science perspective and new scholarship that is emerging within the context of biases and everything, is that probably artificial intelligence is neither artificial nor intelligent. Thank you.
Thank you very much, Dr. Akansha Nandani. Thank you all the audience for the time and the distinguished speakers and all the guests here. With the permission of Honorable Chair Thiru M. Karunanidhi Garu, we'll break for lunch and close the session. Thank you very much. We'll break for lunch now. For the audience who are joining us online, we're running a little late on the schedule, so we'll be beginning the next session in another 25 minutes. Thank you. I request Honorable Professor D.P. Verma Garu, Uday Shankar ji, Rohan K. George, and Vishwam Jindal Garu to please take the seat on the dais. Rohan sir, would you please take that? Yeah. Sure. Yes.
Oh.
Vishwam Jindal. I introduce the Honorable Chair for this session, Professor D.P. Verma Garu, who is a member of Law Commission of India. Before we go towards, we have Mr. Srinivas Rao Mahankali, CEO, Technology Hub of T-Hub of Hyderabad, who could not join us unfortunately today. However, he has sent in some notes for us to touch upon. I'll briefly read those notes and then we can go on to the address by Professor D.P. Verma Garu. Mr. Srinivas Rao Mahankali Garu says that AI has a potential to significantly enhance the efficiency of legal services while maintaining the integrity of justice. And he identifies around 6 points for us. Some of them are streamlining legal research. For instance, AI tools utilizing natural language processing, NLPs, can provide precise legal precedents and relevant case arguments much faster than human researcher, is what he says. Additionally, enhance contract analysis, which we do often daily. AI models like ChatGPT-4, he says, can review contracts in an average of 4.7 minutes compared to over 3 hours taken by some average junior lawyer. This efficiency not only speeds up the process, but also enhances accuracy, reducing the likelihood of costly oversights. And also he says predictive analytics for better outcomes is what is given by AI using historical data present with it. Additionally, cost reduction is of course an important point, and improving client experience also. I think Mr. Rohan, who joins us here, also has certain products for AI and client improvement. I think Mr. Srinivas Rao Garu would have definitely discussed about this. He says improving client experience by providing faster and more accurate responses to inquiries, handle routine queries, scheduling appointments, and provide updates on case status. And also, it helps a lawyer to free up on his complex tasks. But he also says that ethical considerations and oversights must be carefully and responsibly taken into matter by making AI which are transparent and accountable. And we have to develop regulations and guidelines which can mitigate this risk. And he later identifies the key applications which already the other speakers have mentioned. And he speaks about algorithm bias and transparency and accountability mainly. And procedural fairness is something also he touches upon. And then the implication for justice and emerging thing, he says that enhanced access to justice is of course ensured. But he also emphasizes on the changing roles of legal professionals. For example, he says the shift of legal professionals might happen, raising questions about legal expertise of a human legal expert. While AI can assist you in legal reasoning, complexity of all, but it still necessitates human judgment and ethical considerations, is what he primarily points out. He calls for regulatory frameworks and calls it a pressing need before us. With this, he encourages continuous dialogue with all the members and the fraternity present here. This is what Mr. Srinivas Rao Mahankali Garu, CEO of the T-Hub of Hyderabad, wanted to stress upon. With these wonderful points, we move on to the address by Professor D.P. Verma Garu, member of Law Commission of India. Before that, I also request all the speakers to kindly restrict to the time limitation since we are already running little short on time. Thank you, sir.
Since I have been asked to chair the session, I feel that the other resource persons must be given opportunity to first address on these issues. Then the last word will be mine as a chairperson of this session. Therefore, you request the other resource persons.
Certainly. We will now proceed to the address by Dr. Uday Shankar Garu, who is an associate professor at Rajiv Gandhi School of Intellectual Property, IIT Kharagpur. Sir.
Thank you very much. At the outset, I express my gratitude to the Law Commission of India and Nalsar University of Law for extending this invite to me and to give this platform to learn and also to share my ideas on this very important topic, which in fact is making a buzz not in only business world, but also in law and legal circle. Good afternoon to all of you. Respected Professor D.P. Verma, sir. Teachers of teacher is known in the legal fraternity, legal academia, to all the teachers in a very reverent way. So thank you for chairing the session and giving the floor. Mr. Rohan and other colleague in the panel. The best part of this topic is that there's a lot of overlapping because everyone is somehow talking on the same challenges. Everyone is talking about the same potential. And therefore, the question comes up that how do we really distinguish? In the time slot given to me, I'll try to make some distinction and kindly excuse me if there are overlappings as well. Looking at the ongoing issues with access to justice in this country, I divide the issues in two parts. One, I say, is an issue related to justice to access or access to justice, the way you put it, either way. Or the second one is access to judicial institution. Purposefully, I'm dividing this in two parts. Access to justice and access to judicial institution. Good number of cases which are pending at all the levels of the judiciary in India gives us a very good feel that we do have confidence in our judicial system. Pendency, honestly speaking, does not perturb me. In fact, it gives me a good feel that people are having faith in legal system, and that's why they are approaching formal legal system. And because they are approaching formal legal system, I see that we have been doing very good on the aspect of access to judicial institution. Everyone is approaching the code of law. Access to justice is an issue because if pendency is not addressed on time, then access to justice becomes an issue. If litigants are not getting remedy relief on time, the trust factor gets compromised. Shall we look at the use of AI from these two approaches? To me, yes. To begin with, the very idea of understanding justice in the context of AI, that how we really try to do a kind of matchmaking between AI and justice. Because the question comes to our mind is that whether justice has any technical attribute in it. Because unless and until you look for some common thread, common denominator, you cannot really build the relationship between AI and justice. So justice implies consistency, both in the process and the result. In the morning session, Dr. Daniel was referring to about it. That is about treating similar alike, what all of us have been reading in reference of Article 14. Justice also indicates a process that is free from coercion, no external influence. And it also ensures that inequality between the parties does not influence the outcome. And there where technology becomes the greatest enabler to my mind. Because when you look at the traditional process in the court, you find that inequality between the parties somewhere influences the outcome. Who has got what capacity to engage lawyer? And accordingly, somewhere things get determined. Without becoming a judgmental on this point, just indicating a fact, just indicating a pointer that how we shall look at justice. Third point to me is adherence to the values of procedural fairness, which all of us have been talking about. Speakers in the first session talked about transparency in the algorithm. How shall we maintain that? In addition to adhere to the values of procedural fairness, it is also important that parties are given the opportunity to defend their case and to answer contrary allegations, which I believe is a way forward when we talk about connecting justice with AI. That any AI-driven system which is going to get employed in deciding the outcome, there must be some kind of appellate provision should be there in order to maintain that fairness. Unbiased, neutral decision making is another important aspect of justice. And then it also says that decision making must have the attribute of open and reviewable process. Now, when we look at these attributes, we are trying to understand that should AI complying with these attributes? If answer is yes, we should be happily accepting it. If answer is no, we should resist, because justice is such a value that in no case it should be allowed to be adopted in any compelling atmosphere. It must be adopted, accepted only when we are convinced that AI is going to comply with all these values. Now, I try to look at another important attributes in justice, that is technological attribute. I would put it socio-technological attribute. In a way that justice also demands efficiency. System must be efficient, and technology can really play a critical role in influencing the same. So when you say that justice delivery system or justicing as a service must be efficient, I see technology as one of the attributes in connected with that. How we are contemplating or already we are using artificial intelligence in justicing system. One is registration of cases and the identification of procedural compliance, which I connect with the second aspect of justice, that is access to judicial institution, where if you use AI, then you'd find that much of the efficiency would be achieved, and already that is there in place. Filings are happening with the help of technology. In the first session, there was a discussion also that how it is being contemplated that summoning should also be done with the help of technology. So access to judicial institution, we find already AI is playing role. Online submission, remote submission of procedural documents to the court in electronic form, obtaining information about the progress of the case, participation in court hearing, receiving copies of the judicial order. All these are already in process. So much so that the live streamlining of the court hearing is, to my mind, strengthening rule of law and democratizing judicial process. Everyone can participate. And the Honorable CJI has now also made an experiment of running the transcript of the process, which in a way is making everyone aware and informed, which is the factor of establishing rule of law. Access to judicial institution. When you look at the use of AI, you find that AI is playing a very critical role, defining role already in place. The problem comes up with AI in justice. What you call it as in assisting a court or in replacing the court, whichever way you look at it. In assisting the court, to what extent it should go. In replacing a judge, to what extent it should go. Assisting the judiciary, there is acceptance to this proposition to a large extent. People are saying it's fine if AI summarizes the precedents, apprises the court about the validity of the documents. It's absolutely fine. Let the judge accept it, and then on the basis of it, let the judge decides on the matter. So assessment of evidence and establishment of legally significant circumstances, which I related with access to justice, AI can play an important role. Already we have instances at hand where it's playing role, for example, in criminal justice system, in other jurisdictions, how the risk assessment algorithm is helping the judiciary in arriving at the decision that should there be bail or it's a case of refusal of the bail. To assist a judge, what AI can do is that it can analyze judicial precedents, which is referred by the parties in claiming their points, in establishing their pleadings, and how those law points which are advanced by the parties can be made applicable in the case at hand. There where I believe AI can play an important role. Again, here I'm emphasizing on access to justice, not access to judicial institution. The other one where AI can play a significant role, I believe, is distributive justice. If you look at the role of technology in improving distributive justice, in relation to other branches, it has done phenomenal work. For example, financial services, it is doing wonderful, it is giving wonderful outcome. I believe even in relation to judicial process, when the matter involves a distributive justice, AI can play an important role as long as the basic idea of fair equality of opportunity is maintained, and the very principle of distributive justice that resources are to be distributed in such a way so that least advantaged also features in the larger scheme of justicing. So there are different stages of use of technology in justice delivery system. The government of India has been investing a lot in improving digital infrastructure, computerizing the code, the digitization of records, all these are being done. Assistance in procedural aspects has already been done, where we find video conferencing and court services which are available online. Language of proceedings is another one area where AI can play an important role. Already an attempt is made by introducing Subhas by the Supreme Court. I believe it can further be, upscaled, where the entire proceeding can go in different languages, and that is something which I believe possible with the help of AI. tools like chatbot or can play a very significant role in, again, accessing justice system. For example, let's say I am there to lodge a complaint in the police station about an offense which has been committed. If I keep on giving the details to chatbot that what exactly has happened, and it is the system which tells me that, okay, this relates to this offense. And if there is some perfection achieved in it, then it would be convenient to the complainant as well as to the investigating agency. So access to justicing system can play a very important role in improving the justice delivery system. I'll conclude by highlighting the concern and what shall be the way ahead. Concern is how do we really address the issue of privacy? That's the biggest concern, because newer regime demands emergence of newer rights as well. In this case, is the right to privacy. How do we really do the balancing? Particularly when there is an issue of accessing sensitive data. How do we really ensure that the technology which is deployed is tested before deployment? That's very important to look at. One way of addressing that is, can we envisage, we have experts from technological field also, can we think of AI, having AI benches as we have in the judiciary? Can we think of training AI in different technological tools and give the problem to those technical tools? For example, AI based on large language, AI based on machine learning, natural language. Because when we say that human judges are deciding on a legal dispute, we are believing in the judgment making. Here also, through this process, the very belief can get enhanced. So can we think of this similar thing? Second one is, we need to make a distinction between how do we look at civil justice with alternative dispute resolution mechanism, because the deployment of AI should accordingly be planned. What we plan for civil justice need not be for ADR, because in ADR, affordability is not an important element. Civil justice affordability is an important element. Whatever we plan, it must be affordable as well. So we need to be a little careful on that, because when I look at the attributes of civil justice, I find it must be accessible, it must be effective, it must be affordable, it must be without discrimination, it must be without any corrupt practices. When I look at ADR, it must be effective, impartial, and accessible. So are we suggesting something which shall be applicable universally? We need to think about it. To conclude, I would say that AI is presenting a wonderful opportunity, revolutionary change from welfare-oriented system to accountability-oriented system. And if we deploy it with all strategy at our disposal, I believe it can certainly realize the goal of accountability-oriented system. Thank you very much.
I thank Dr. Uday Shankar Garu for his wonderful address, emphasizing on the Chief Justice of India's initiative led by him of the Supreme Court of India. I think on Friday, the second hackathon also was announced by the Supreme Court, which is quite relevant for all the increasing discourse on AI and law here. Thank you, sir, for your address. I now hand over the address to Mr. Rohan K. George, who is started the AdIDM in organization Chennai, who is our own very alumnus, and he was a partner with Samvad Partners until recently. Thank you, sir.
Can you there we are. It has to be downloaded separately. You'll have to download it. It's already up there. Present to the audience joining online. That way. Oh, to the audience joining online. Correct. All right. How will you share? We have to share it. Perfect. Okay. Okay. Hey everyone. I actually want to start off not by starting with my experience, but I wanted to respectfully request the students here to share their ChatGPT stories. And I know that ChatGPT stories are very tough stories to share. So I would just suggest you start by saying, I know a friend who did this, instead of saying you did it. But I want to know how your interactions have been with ChatGPT when it first came out and what you did with it, what mistakes you made. Can anyone share a story about a friend of theirs who made a mistake or had something? Yes, please. Thank you.
I was in my second sem. I was interning under a litigation chamber, and yeah, my friend did it. So not even my friend, it was a co-intern. He had completed his 5-year undergraduate and all. So what he did was, we had asked him to prepare a research note on a particular legal question or a legal proposition. That is the task. And he did. All of the office was working on that one proposition since it was hard. And that guy did it in around 2 hours. And then he submitted his research note and left. He gave around 6 cases on a proposition in which none of the interns could get any. Everyone was flabbergasted. How is this happening? And once our main advocate, he looked through the cases, none of them really existed. So they were all ChatGPT, and he got kicked out the next day. So this
Yeah, I
is
bet.
one thing.
That's interesting. Anybody else has the story?
So some internships have ChatGPT blocked on their
Interesting.
Wi-Fi.
So here's goes, like I was not, my friend of mine was mooting and we were doing some research about the same. And surprisingly, everyone in their moot proposition had the same case laws. And the case laws, which actually exist, but the data which it was stating does not exist. And we were favoring, like we made our arguments, we framed according to that. And at the end of it, we found out, okay, this doesn't exist. When we actually read the judgment, which was of course 200 pages long. So we just thought, okay, ChatGPT would do a better job, but ultimately it doesn't.
Yeah, that's interesting.
So I had a similar experience in this regard. So apart from ChatGPT generally hallucinating with wrong info, there's also like one issue I've seen through AI generated text is that they often tend to read very bland. And at times when you are like, making moot submissions or legal submissions, there has to be certain nuance in it that is missing from that text. So even if you put your own research into it and try to draft it completely using AI, that doesn't help. And the text seems to be lacking the personal touch that is required, the nuance that is required, and the kind of, character that is
human
required.
feel.
Yes.
Yeah.
So that is one thing that I've noticed across a lot of texts. And these days I see that a lot of articles on the internet or generally like submissions that we receive for blogs are AI generated like that. So that is one issue I have observed.
Interesting. So I mean, yeah, you're saying something.
Like rather saying a friend of mine, a senior of mine, actually tried, while we were doing a research
on understanding, giving a client an advice on the share transfers or issues on right to first offer or right to first refusal. So we try to do a AI research and an AI, we try to give a consultation through AI mechanism. But it turned, as earlier speakers said through, we got fantastic replies. I mean, fantastic. It came out to be structurally, it was really great. But when we started looking at the case laws, there never existed anything like that. So
Okay.
yeah.
No, I'm seeing an interesting common thread here. A lot of you have had friends who have used ChatGPT for a combination of tasks. Actually, if you'll see here, one part of the task was drafting, right? And you guys were thrilled with the results of that task. One part of the task was research, right? And nobody was thrilled with that task, right? And why I'm highlighting this is because, if you had a person who went through an accountancy course in a school, or if you had a person who went through a medical course in a school, there are certain standard issue tools which they would have to work with. They would have been trained from the outset with those tools, right? You can't go through an accountancy course without at some point having an entire module on Tally. It is that integrated in the accounting profession. You can't have a course on medicine without at some point having to work very carefully with the kind of medical diagnostics tools which are accepted in medicine today, at least the fundamental ones, right? Let's say radiology. You can't do radiology without understanding how an X-ray machine works fundamentally, right? These are professions in which technology has been integrated from the get-go, okay? CAD and 3D modeling doesn't even exist today, by the way, without having to actually sit and go through Blender or various other 3D modeling tools. But in law now, we are suddenly experiencing an inflection point, right? I would not say a first inflection point, but another inflection point, because I was fortunate to be a law student at a time when there was another inflection point as well, and I'll get into that. You have suddenly found a place where you have technology which is capable of creating and manipulating language, and you're making mistakes as you go along and learning how to use it. Now, there are two things which you'll have to be clear about as far as this is concerned. This is not the first time this has happened, but in law it's happened very rarely. Okay. The current state of play in the legal profession, basically prior to ChatGPT, was that there were two major technological disruptions which occurred, which in some way or the other changed the way legal practice occurred. This is the first one. Microsoft Word, okay? That came out in the early 1990s. And you may wonder how Microsoft Word significantly disrupted the legal industry, but you'll forget that as there was a point in time when lawyers would hire an entire secretarial pool, and the strength of output of a lawyer's office in terms of both documentation and pleadings and everything was determined entirely by how fast and how efficient the secretarial pool is. After MS Word, and of course, obviously after the laptops and systems which enabled that, one single person could enable the same kind of output, which maybe a secretarial pool of maybe 10 would be able to enable for the same, well, basically providing the same kind of synergies. This is the other major disruption. You can call it Manupatra, you can call it Westlaw, you can call it anything else which you want. Maybe about a decade later, you had the introduction of online legal databases. Again, how did this disrupt? Once upon a time, when you had a portrait of a lawyer taken, this is the background against which that portrait would be taken. A massive library full of books, very beautiful books, leather bound, and a lawyer's status and symbol and significance was determined on the basis of those books, basically, what they look like. Like, obviously, I mean, I don't need to show you this DALL-E created image to tell you that this is no longer relevant, but it is no longer relevant, right? This entire library and more can fit on a mobile phone. And it's not because of the phone alone, right, that you can do this. It's because the technology enables online legal databases and information retrieval. Okay. So before I get into this, we are now, I think, I'll share my one of my interesting stories actually about this sort of situation with you, which is when I was studying in Nalsar, and MS Word was one thing which actually people had started adopting relatively recently on a regular basis. Otherwise, we used to handwrite all of our project notes. I'm going to try and make sure this is not a nostalgia trip, but I'll tell you what I recall about inflection points in legal practice, more importantly. The second was these legal databases. Okay. At the time, of course, we had a massive library, and I'm sure already we still have a very well-stocked library. But there was still a point when you would have to look up the relevant manual AIR citation in order to find a decision, because the entirety of legal cases had not been uploaded onto online mediums at that point. But that was happening very slowly and quickly, and I mean, very slowly and efficiently. And by about the 4th year, I was interning in a particular law firm, and Manupatra had most of this information available. And, similar to, her story over there, you were talking about the internship story. There were a lot of other people who were working on a particular legal research point. And, they gave it to me as an intern so that I could be busy. And I was able to find a case law very quickly and very efficiently because I understood a little bit about Boolean search, basically. So Boolean search functionality actually really exponentially improves your ability to search things like Manupatra, wildcards and such like. Then somebody pulled me aside and said, look here, you please sit down and tell us how to do this, because this is something which should have been figured out much longer ago, but we don't have an ability. We're talking about an intern, and this is not a special story for me. It's a story which basically could have happened to any of my friends, and indeed happened to a lot of my friends. They were all at inflection points where there was an entire generation of lawyers who had been trained using one methodology of case law retrieval. And they were encountering another generation of lawyers who had a different method of legal research, right? And those were intelligent, upskilled, and were trained by the subsequent generation. That's not to say there weren't enough people in our group of lawyers or in our cadre or batch of lawyers or cohort who continued using older methodologies. But those who use new methodologies definitely saw benefits from them. Why I stopped into that segue is that at this particular point, we have a few specialized and expensive walled gardens of tools. Your ChatGPT is general purpose. It's like a Swiss Army knife, right? And I have a ChatGPT story, which is basically about how I figured out that ChatGPT is something which is going to change the way in which legal practice works. I got a subscription to it somewhere in February 2023. And I was playing around with it the same way a lot of people would have been playing around with it to see what you do with it. So then I decided I wanted to draft something called a technology transfer agreement. Technology transfer agreement is a bit of a bespoke agreement. It's not something you can just pull a draft out of online. You need to have some kind of background or template. So I started off drafting that, initially got a skeleton, then worked along with that skeleton on how do you put it? Now what we understand to be using a process of what you call chain of thought prompting. And finally arrived at a draft which I would not have been embarrassed to give a client if I was working as an independent lawyer. And this was using what I consider to be a Swiss Army knife. So then that's my point at which I decided that, this technology is going to really change the way in which the legal services industry operates. And I would rather be involved in the change than just to watch it happen, basically. So yes, what happened before this? There was AI involved. There was some amount of interesting technology. There were very, very powerful, but very, very restricted walled garden tools like Luminance, which were available for £1,500 a month. Clio, which is about 120 dollars per person. Patsia, which is for patent-specific tasks, which is about $900 per user per quarter. But, ChatGPT has kind of disrupted that entire, not ChatGPT. I mean, I keep using the word ChatGPT as a stand-in, right? There is enough and more. There's a world of large language models. They have disrupted the existing industry around machine learning enabled legal technology. And what exactly are we talking about when we talk about that? First, let's get an understanding of the fundamentals. Again, I have a feeling a lot of you will understand this. Do you think that these existing large language models are AI? Anybody has thoughts on whether they are AI or not? Anybody? Sure. Yeah. All right. But what is AI in your opinion? Sorry, two different. You go ahead, please. So AI is a mathematical model. All right. Okay. Sorry, there was somebody else who said something. It's a stimulation of a simulation of human intelligence. Yes. So I mean, like, the more commonly understood in meaning of an AI is that it is meant to be, sorry, you have one more input. Sure. No, understood. Understood. But no, I'm sorry. I'm very focused on just getting the idea of what is AI. And you're right about that point. That's a deeper one. The idea is that AI is using, through artificial technology, through non-human technology, the simulation of human technology, of human intelligence. Human intelligence is very important, right? Machine learning is a pathway to achieve AI. Nothing has achieved AI right now. There is no situation where you are sitting and talking to somebody, as many people have mentioned already, right? Machine learning is, and you don't feel that you're talking to a completely natural person. You can't ask about a whole bunch of things. Machine learning, on the other hand, is simply a pathway to get closer to AI without necessarily achieving it, where you basically take a large amount of data and you feed it into a machine, an algorithm basically, and it learns how to perform certain actions on the basis of the data. There are many categories of machine learning. Predictive analytics is one variety of machine learning. Computer vision, basically, where your facial recognition systems and such like are a variety of machine learning. They see so many faces, they know the difference between all these faces. After a certain point, you show them X person's face and you show them Y person's face, they know the clear difference between the two. Machine learning. All right. Generative models are a subset of machine learning where you feed large quantities of data into a system, specifically the objective of getting it to generate something like that. All right. You feed large quantities of pictures into a system with the objective of being able to generate a picture. You feed large quantities of video and text because you need to find a way to correlate the two, right? You need to basically provide large quantities of tagged video to the system and then have it generate a video. A large language model is a variety of generative model. It's what a large language model is inherent in the name. The word model. The word model implies that the large language model is a model of something. What is it a model of? Does somebody have a thought on this particular point? Sorry, I couldn't hear that properly. Okay, so it's a model. Fine. All right, I'll take that. Anybody else has a thought on this? I'll give you what I consider to me my analysis of what the word model in this context means. This is a model of human language output. In other words, if you have a large language model which is trained for conversation, what you have is a model of conversational output from a human being, input and output. Okay. You have a large language model trained specifically for coding. Okay, there are LLMs now which are only trained on coding data or trained primarily on coding data and a bit on natural language data so they can understand natural language. Those are models of output of coding language, which is a language by itself. You can express yourself in coding language. So in other words, a large language model is a model. It's a model of language, that much is obvious. It's large because it has been trained on a very large training data set. Do you have an idea of exactly how large a training data set normally, like just for sample size, a large language model would be trained on? So if you have something called a 7 billion parameter model, which is basically one of the, I wouldn't say one of the smaller, but one of the more, the smaller the mid-sized functional language model which we work with in our work, right? Then it has been trained on a factor of 7 into 3, 21 billion parameters, which 21 billion tokens, which basically every token, when you I'm sure you guys have worked with ChatGPT and you come across token limits and such like, right? You're familiar with what a token limit is? To move things along and to make sure that I don't run out of time, I'm going to tell you what a token is basically. Oh, that's happening already. A token limit is, a token is basically a breakdown of a word into the constituent parts of it which are capable of being understood by a language model. All right. Very often you can account for one token being equal to approximately 1.5 words. Okay. So when you say something has been trained on maybe like 1 trillion tokens, you can then understand, just have a vague idea of understanding how much language has been used to train it. As a result of which, it is capable of providing you output, which is, how do I put it? Which is going to write you a story, help you draft a letter, be able to write legal documents. But now people are trying to focus these things in a much more focused way. So this is what a large language model is. And we won't get into autoregressive models right now because we are running out of time. So how does the new wave of language of AI have the potential to disrupt legal services? Let's have a look at a few basic case studies. All right. And my focus here is to approach this from a commercial law perspective because, to the largest extent, this is how I practiced. So I am most interested in commercial law use cases for artificial intelligence. One use case is the idea of using AI for contract drafting, right? There are a lot of models out there which are being used to create contracts, not from templates or from pre-filled forms, but from actual context. Okay. You get the draft you want in minutes, not hours. You're allowed to automate contracts with just the smallest clause changes, basically, and you can create them in that particular way. And contract review also is something which is done much more simply. I'll give you one example just to look at because this is always much more interesting when you see what exactly is happening in the field. So this is, for example, one company called Robin AI. They have a word-enabled plugin. As you can see, there's an NDA over here. I don't know if sound is actually enabled or not. No, it's not.
Is cutting-edge technology available directly within Microsoft Word. Get ad hoc drafting support, summarizations of key clauses, and find information buried across hundreds of pages and more. Ask questions and get answers referencing specific contract sections to validate information quickly. Playbooks provide AI-suggested edits to streamline contract review. Legal professionals can accept or dismiss suggestions as required. The tool provides a highly accurate and precise way to mark up your contracts that minimizes redline. In seconds, check to find terms are correct and add the parties to your contract. With Robin AI, the possibilities are endless when it comes to enhancing accuracy and accelerating contract review. Enhance productivity. Sign up to Robin AI today.
Okay, so I wanted to show you that because I wanted to give you an idea. Here we are.
Robin AI's Contract Copilot integrates AI directly into your day-to-day workflow. Legal teams around the world
Of what exactly is being done using legal tech at this particular point, right? What you're seeing here is AI, which at least is at this particular point able to act as a co-pilot and help people get to the point of drafting contracts that much faster. It is not very unusual to imagine that there is a continuum along which this will basically be a completely automated task, okay? This is, for example, something we've worked on, a worked co-pilot, which allows you to be able to generate, review, or be able to analyze Word documents right alongside your document, which is not like particularly different. There are many companies doing that. Another alternative use case is automating compliance itself. One example is something which we worked on, which is a privacy compliance tool. Basically something which takes a privacy policy from anywhere and examines it for the factors which are corresponding to the DPDP Act and gives you a language-based analysis of whether your privacy policy is compliant with the DPDP Act. I'm showing you these are a flavor of what direction, private law adoption of legal tech tools is going, basically. The third is something which I specifically want to show you. There is one particular problem which especially a lot of you may have seen in the course of your internships. You're given a new case file and you have to start understanding all the details in the case file and provide a timeline and a list of dates and key documentation as soon as possible, right? That can take anywhere between 4 hours to a few days to a few weeks because it's a fairly complex task going through every document in the case file. Our objective here is to create something called consensus, which I call consensus. And here's a short demo of it. This will take about 4.5 minutes, and I'll wrap up very shortly after. Something seems to have, oh, something wrong with it? No pressing link. Oh. No, that was different. Support 9. Okay, fine. All right. Okay. It looks like this is something which is not supported on this version of PowerPoint. Never mind. The basic idea behind this is to be able to take a case file or a typeset and be able to walk you through this particular case file. Hold on, sorry. The last attempt to see if it will work. No. To be able to walk you through this particular case file and be able to create essentially an entire set of briefing materials, timeline, list of dates, summaries, and various other documents on the basis of that case file. So it's called consensus because it's enabled in order to ensure that multiple stakeholders are able to work on the same project together. Okay. At this particular point, these are the capabilities we have in development. And they involve the automated generation of drafts or pleadings or awards, intelligent research and analysis, a virtual doc room for client and counsel interactions, and a dispute management dashboard, along with a due diligencing platform. We've already had a lot of discussion on the issues around AI and such like. In the course of our conversations now itself, I think you've realized that there are situations where hallucinations are something which are part of it. And I'm sure by now you've already figured out a way to deal with the problem of hallucinations. The simplest one is this, basically, right? Taking ownership of your work. Essentially, what that means is that if, as the lawyer learned or the intern in this particular case learned, if you are submitting AI generated content, you're not going to be able to palm off your errors onto the AI. The buck will stop with you, basically. As a result of which, this is a fundamental principle, which is one of the several principles of AI ethics and regulation across different systems. Keep a human in the loop. The human loop is a fundamental principle which, whether you're an operator or a builder of AI tools, you need to have in the place, basically. Privacy and confidentiality, we've already talked about. There's a significant issue with privacy and confidentiality and AI. And the main solution for that, as somebody who's working with AI, is to be sure that what you're talking about, look at the external certifications and the privacy policy of the AI itself, and use data privacy, and basically don't include personally identifiable information when you are uploading this kind of information on an AI system. IP we've talked about earlier, but this is not a problem which directly is faced by the users of AI. This is probably a concern which you've seen addressed at different points in time in terms of role and job redundancy. And again, something which you might have thoughts on as far as AI is concerned. Do you feel that there is actually a concern as far as role and job redundancy for the legal sector resulting from AI? No. Okay. So you feel that there isn't. Could you elaborate?
all the possibility can be wrong. Cannot update that.
Yeah, that's a very good point. There are a significant number of soft and strategic skills that lawyers need to develop, which is, I'm paraphrasing what you said, but correct me if I'm wrong. There are soft and strategic skills that lawyers need to develop in order to actually effectively work with the client. And merely having the formal ability to draft and modify and research is not going to satisfy that particular requirement. I'm in complete agreement with you there. But what that might mean is that, and this is how most law firms and legal organizations view their hiring process. They see a pipeline of X amount of work, which is X amount of hours devoted to the generic work, which involves drafting, researching, and reviewing, and X amount of hours devoted to the soft skills work, which you talked about. If that amount of generic work comes down, then the number of lawyers they have will still come down. I get your point though. That is why lawyers cannot be replaced. But what I'm trying to say is it's not why lawyers can be, a number of lawyers required for a job cannot be reduced significantly. Yes.
Sir, in terms of, since the discussion has come to this point, I also feel the level of rigor of law students might also get affected, because two examples. One is if I'm preparing for a moot and I'm using certain international moots, even advocate for using AI. They have sessions held over for that. So I think normal course of before AI, when we used to stumble upon multiple cases, have multiple perspectives, and even discover stuff we did previously. Secondly, project submissions. For example, I have a project submission tomorrow, but I'm comfortable with this conference right now because I have artificial intelligence and other means to assist me if not complete. Very honestly. So don't you think it's reducing the rigor and required for a law student is going to be a lawyer tomorrow?
See, I think, it's a good question. This is a question a lot of people have asked, including, like, for example, senior partners ask, right? All of our lawyers have learned their skills in a transaction by sitting and reviewing documents repetitively, by doing due diligences, and by doing those tasks. And that's how they have learned, basically. And it's a very good question. I wouldn't claim to have an answer, except I'll say this much. The time which then a junior lawyer could have spent on reviewing, doing due diligencing, and other such tasks can now be spent directly being involved in strategy and structuring. The time which you might have spent banging away at the keyboard in order to create your draft can now probably be spent reviewing the initial zero draft. You should always probably think of it as a zero draft provided by your AI assistant, and reviewing aside each and every one of the sources which you have been using. Every time saving which is introduced by an advancement in technology makes us as human beings weaker in some way, but frees us up for other tasks. We invented the spade because we didn't want to dig up the ground all the time with our hands. It obviously made us weaker, but obviously freed us up for other tasks. So the main point is to see what those tasks which we are freed up for will be, which is a sociological shift which will probably happen over the course of the next, 5 years, 10 years or something like that in the legal industry itself. But that's my only, limited answer to this question. Okay, I think I'm out of time. So thank you very much. I wish I could have shown you the video, but I'm afraid it doesn't seem to be willing to load another time. Thank you.
Thank you very much, Mr. Rohan George. I think this is a testament to the fact that lawyers can go into any discipline, learn a lot about it, and apply our legal skills, for our legal fraternity there. It's really a testament to that. We now move on to the address by Senior Associate Pallavi Sondi. She's from Ikigai Law, and she's based out of New Delhi. I request the speakers to kindly limit their speaking time to the restricted given time. Ms. Pallavi, the floor is yours. You're on mute. Yeah.
Am I audible?
Yep.
Hi everybody. Thank you to NALSAR and the Law Commission of India for having me. I unfortunately couldn't be there in person, but I'm glad that I can join virtually. And yeah, thank you to my fellow panelists. I actually wanted to go down a different tangent, but I actually wanted to share now my own ChatGPT story because as a segue from the previous session. So I've been a tech lawyer for the past 6-7 years now. And in just one of those instances, which we face, I had to turn around a license agreement overnight. And I used a mixture of AI tools. I used ChatGPT, I used Claude, etc., to actually feed in information that my client wanted. This is what the licensor wants, this is what the licensee wants, this is what the term sheet says. Can you please help me draft a clause? And I was actually and this was one of the first times I was using a AI tool, because I was actually wary about using tools like this, given everything that we have heard about the results that we get. But I was actually pleasantly surprised with the first cut that I got. And I think Rohan spoke about this, that treat this as a zero draft, which is exactly what I got. I got a very good zero draft, which otherwise I would have spent many hours trying to get. And then it was a matter of then applying my mind and using my then sort of own application of mine to be able to better it. So that's my own sort of story. And I think somebody asked a question on, do you think it will reduce the rigor? And I think there I want to take a step back and say that we have to treat AI as a technology. It's like saying that computers reduced vigor. What they did was they made life easier. They made things, they led to automation, things that usually would take hours and hours. Where we were able to do crunch numbers, analyze a huge amount of data in a short amount of time, and then spend our time on other things which the system can't do, right? That human loop and that application of mind that the system can't do is where we focus our energies on. So that's the context I wanted to set. Right. So my sort of what I want to speak about is divided into two. One part of it is AI in the justice sector, and I have been a litigating lawyer for 4-5 years, the initial part of my career, where I can actually speak from experience on what are the kind of issues, inefficiencies, etc., that the justice system currently has, which will really benefit from something like AI. And my fellow panelists have spoken about this at length. And me as a litigating lawyer has personally faced these issues, and anybody who's been to court would know things like how you have to on a particular day when your matter is listed, you do not know when that matter is going to come. You have a list, right, but you don't really know. You have to wait around. So that kind of case management is just one of those many sort of use cases that AI can be put to, right? And we can see work that's already happening. Of course, we have the e-courts project under the Ministry of Law and Justice and the Supreme Court's e-committee that is sort of, which marked really the start of this journey to incorporate AI in the justice system. And we can see support as well, right? From, of course, you have the Chief Justice of India, etc., who's saying, sort of promoting the use of AI in the Indian judicial system. You have about, I think there was a budget outlay of 1,500 crores for the e-court mission to be able to incorporate AI. So that kind of infrastructure support is there. My fellow panelists have spoken about the tools which are already being used. You have Supase, you have Suvas. A lot of these tools are already started to being used. But I want to take a step back and actually focus on what's the litigation life cycle and where all can AI be actually plugged in, right? Because the litigation life cycle actually has a plethora of opportunities, right from the instance where you file your case. Right now, we of course have e-filing, and that's something that the pandemic taught taught us that can, it's really become an efficient system where e-filing is happening in many courts. But right from that system, from the stage that the case is filed, AI can sort of be used in the litigation life cycle. To be able to automate what the registry does to admit cases, to ensure that the cases that are filed comply with all procedural compliances. This is something the registry does currently. Then, of course, we have spoken about certain matters which are low stakes, or where essentially there needs to be application of facts to sort of, predetermined principles. You have land disputes, you have motor vehicle claims. These are also cases where AI can be used, and we have precedents, global precedents here. You have in Australia, for example, you have something called the Australian split system, and that they are actually using it with a lot of success to solve family law matters. Even in the criminal litigation life cycle, you have things like monitoring bail applications. And I believe Kerala High Court has actually started this, and they've sort of found success also. They've modernized the bail application procedure, where they've sort of incorporated a technology that can themselves sort of assess whether the bail application fulfills all criteria or not, right? So that's the life cycle, litigation life cycle, where AI can be plugged in. There are also certain challenges in the justice sector, right, where we can really use AI. One of the biggest challenges is the judicial vacancies, and we have some stats here that there are only the Law Commission's report itself highlighted that there are only 21 million judges per million population. So there is the vacancy, and there has been a lot of literature supporting the fact that AI can really be used to sort of fill this vacancy as well. And another interesting sort of use case that there's a lot of traction around this is using AI to actually figure out whether parties should litigate or not, right? And this has actually been successfully being used in certain European nations, where they have developed systems where parties, before even wanting to litigate, they've put in their facts into the system, and the AI system is able to advise them on whether you should go for alternative dispute resolutions, should you actually litigate, what are the chances of you actually finding a solution, how many years it will take. So that is also something that will really assuage one of the sort of issues that is plaguing our judicial system, which is, of course, the huge backlog and pendency of cases that we have. And we could see many other examples of this. One interesting example I was reading was in Estonia, the Ministry of Law and Justice has actually designed a robot judge, which is able to adjudicate small claims. And of course, the ability for it to scale up to other sort of claims is still being developed, but the sort of work has already started. And further, in other countries, in US, in UK, in the US, we've heard about the system called the Compass system, which sort of assists judges to sort of, do a risk assessment of the criminal history, of socioeconomic background of criminals, to see how likely it is that they will repeat offenses. All of that sort of help judges make a decision. And the UK also actually has a similar tool. It's called HART, which is the Harm Assessment Risk Tool, which is able to forecast whether criminals will be likely to repeat offenses or not. So the larger point I'm trying to make here is that a lot of work has started. A lot of tools have been deployed in other countries. Lessons to be learned from there on what are the challenges that are being faced and how they can be deployed in India. Because the challenges of deploying these tools in a country like India is different from how it will be in another nation. And that's really where I think human in the loop comes into play, right? Because we have to understand that why AI is only these tools are only going to help you to a certain extent. And then you need those human in the loop sort of systems to ensure that biases don't creep in. You have your algorithmic biases that happen; those don't sort of creep in, which is very likely to happen in when you're using things like when you're using these tools. And right, and the sort of second thing I wanted to focus for is on when we are trying to use these tools, what are the challenges that can come up, and what are the really solutions that we can think of. And I think my fellow panelists spoke about some of these challenges such as one is, of course, the technical limitations, the costs which are sort of attached, privacy risks, information security risks. We spoke about absence of transparency, which is a huge risk because as far as justice is concerned, right? Because a lot of these AI tools work as black boxes, and to be able, and if they're taking decisions based on justice, then making sure that these decisions that are taken are reviewable, they're appealable. You can inform people why a particular decision was taken. And when we think of solutions, some of this was already discussed, but one is, of course, public-private partnerships, really leveraging that. There's a lot of work that's already happened, but really leveraging how your tech companies can sort of partner up with relevant stakeholders. For example, Microsoft has sort of partnered up with the Ministry of Law and Justice for training judges. So things like that is where we can find solutions. Another sort of a solution is actually publicly available data sets, and this is a solution for, because a lot of the AI tools that we want to use in the justice system need data sets in vernacular languages. A lot of these judgments, a lot of these court orders, proceedings happen in vernacular languages. To be able to have those data sets, to be able to convert them into machine readable formats, that's also another thing to focus on. And right, and the second thing that I actually wanted to focus was about, so we have spoken about the AI in the justice sector, but AI, as far as like my experience as a lawyer is concerned, we have seen in the legal fraternity itself, and I think Rohan also spoke about this, a lot of people have started using a lot of AI tools. ChatGPT is actually being used by judges in court proceedings, though in a lot of these places where judges use ChatGPT, they are often sort of caveated, saying that this shouldn't be relied on, which really goes to show that while there is some sort of awareness about these tools, but there is still reluctance to sort of rely on it completely, and it's because of the fallacies which exist in AI tools. And I think the sort of bottom line here is, and I'll sort of reiterate my point here, that AI has to be seen as yet another transformative technology. Back in the 90s, when and even before that, it was the internet or the computer which was sort of changing the way we do things. It didn't really reduce the rigor. It's not like we rely on the introduction of computers or the introduction of the internet made humans redundant, right? There is the human loop which is involved, and that's how AI should be looked at. Right, and I think we are mindful of time, so I won't take more time. And yeah, I'll pause here for questions if anybody wanted to discuss something.
I thank Pallavi for the valuable address. The questions will be sent over to you on email if any of the students have any questions. We are running out of time here. So thank you very much once again for your address and joining us online. The last speaker, before we go on to the chairperson, the last speaker remaining is Mr. Vishwam Jindal. He's a CEO and co-founder of Vibenye. Welcome, sir. Thank you for joining us.
Hi, good afternoon, everybody. I know we're running out of time, so I'll try and keep it short, but also interesting. I'll try and also not duplicate a lot of the stuff because, since the morning and being one of the last speakers, I think a lot of it has already been said. I'll try and give it a different flavor. Firstly, thank you, Law Commission and Nalsar for this opportunity. So I have been a legal tech entrepreneur for the last over 4 years, doing legal tech before ChatGPT became a thing and became popular. We were trying out some stuff with GPT-3 and previously as well. So I've seen the journey over the last 4-5 years, not only in generative AI, but also other technologies. But I want to start with 1 or 2 short clip videos to basically emphasize what the opportunity here is for us. I'm sure some of you have probably seen this, but I'll just.
Or, the Indian
So how many of you have seen this podcast before? It's Bill Gates speaking with Nikhil Kamath of Zerodha. Okay, so very few people. So this is an interview, and he mentions one thing in 2 places in his interview, which is very, very interesting.
legal system is very different. Believe me, what 2 cases where an Indian company goes after that very base level and hopefully focuses on some specific Indian applications of that. Most of the opportunity is at the level above, where you're saying, okay, let's take this and help architects, or let's take this and help this group of farmers, or, the Indian legal system is very different. Believe me, what legal things are done for the US won't apply here. But, just imagine if you could make everybody in the legal system 4 times more productive. That changes justice, because right now the backlog is kind of nightmarish. And here, comes a potential solution. So I'd say there's 1,000 opportunities where you.
So one of the things he said is, so he picked one thing which can really change in India. If we have to really use Gen AI, it has to be for the justice system and to clear the backlog. And he said it not once, but he actually said it twice. So the second question that Nikhil Kamath asked him is basically, if he were to start a business again, if he was to do a startup again and he was 20.
Okay, last question to you, Bill. If you were 25 years old, living in India, no crazy skill set at hand, and about $100,000 of money to start a business with, what would you do today?
I'd probably pick some AI thing and just use the Google, Microsoft platforms and go on top of that and try and, because I'd be in touch with the customer so well and improving my data, keep ahead. And I'd say, okay, who's the most demanding customer for this? And go after that. It might be fun, like clearing legal backlogs. That one kind of fascinates me because it's a mechanism that helps all business activity. I'd envy the guys who get to work on the foundation models. I'd say
we'll probably pause at that. You can watch it later. But I think just the amount of opportunity we have now to use not only AI but technology to really solve the problem of backlog and arrears, I think is a generational shift. And if we're not leveraging it now, if we're not using it now, then this would be a massive, massive opportunity missed. And of course, I speak for India, but the same applies, for across the third world nation, where countries in Africa, countries in Eastern Europe, and others as well, where there is a lot of backlog as well. So I think we really need to use this opportunity now. And I'll talk about the principles and a couple of other things as well. I think people have already talked about Supreme Court transcription and stuff. But this session is themed in terms of what are the principles for AI and justice. So I was thinking about what the principles should be, and I've sort of came up with 4 important principles. The first is, of course, accessibility. And a lot of it was spoken about in the inauguration ceremony as well. I want to ask a question, and some of you may have read this. It's more of a jurisprudence question, but it actually sits at the very heart of what we're trying to do, is whether courts are a service or a place. When you think of courts, do you think of a place you go to get justice? The judge sitting there, there's lawyers, there's probably a witness box, there's audience, benches for lawyers. Is that what a court is? Or is it really a service which the justice system is delivering in terms of, giving justice, deciding cases, whether, civil, criminal, commercial, etc. And if you look at some of the jurisprudence, of course, this has sort of come out of the UK. But people argue that courts are really a service, not a place. I mean, historically, it used to be a place, fine, you go to a court, you go to a tribunal. But really, if you drill it down fundamentally, it is a service. Look at what is happening in fintech. Banks used to have branches, used to be a place. How many of us really go to branches anymore for anything? Right? So why are we really going to courts now? Or why are we really, having complete digitization in one sector, but really archaic in the other sector? So it comes down to accessibility. And if you look at what happened in COVID, when suddenly everybody had to move online, there was a question in the parliament, and the law minister back then, Mr. Kiran Rijiju, they did some analysis and they said access to justice increased manifold because people suddenly did not have to take chutti from their work and come to court. It's all easy for us, for NLU students and professors and others to say, it's fine. But if you look at revenue courts, if you look at district courts, people, have to take unpaid leaves to sort of go to court. And obviously some states are massive. So you're, spending 1 day, 2 days, just sort of traveling to court, not being paid for that, your daily wage or whatever it is, and then sort of coming back. There's massive loss of opportunity, loss of cost for policemen. If you go to a high court, if you do criminal law, the amount of police in court as well. So we really need to redefine what a court is. And it really comes down to accessibility. And there could be nothing better than the law minister saying access to justice massively increased during COVID because of online hearings. So that, of course, one shift has happened. We've spoken about live hearings. We've spoken about, YouTube streamings and everything. So I won't go back into that. So that was the first principle I think, we can really leverage using AI is accessibility to justice, access to courts, and access to legal advice. I won't be able to cover all three principles, but those are sort of, three in terms of accessibility. The second principle is inclusive. Now, we all talk about diversity, we all talk about legal aid, we all talk about different things. We can really leverage AI to make the system more inclusive. How can we make tools which are specifically designed for women, specifically designed for people with special abilities, specifically designed for minorities, and give them tools to be able to represent themselves in courts. We're doing a pilot with courts in Dubai where they've got this court of first instance where people can represent themselves. In India, that was always a thought process with consumer commissions. But if you go to a state consumer commission, you'd hardly find anybody because the processes are so difficult and it's so archaic that no one really wants to, even represent themselves in a consumer case, forget anything else. So now is really the time to see how we can make it more inclusive, leveraging AI. The third one is probably obvious, which is sustainability. If you use technology, of course, Ma'am spoke about the effects and the water and the electricity that you need to leverage for data centers. Of course, keeping all of that aside, no doubt that that's a big factor. But if you get rid of papers, so there is a campaign, if you've heard of Campaign for Greener Arbitrations globally, they did a survey which said that one arbitration, can anyone guess how many trees you need to cut to offset one arbitration, one say large scale or mid-sized scale arbitration? How many trees you'd have to cut to offset the carbon emissions for one arbitration? Any guesses, any random guesses from the audience? 1,000? It's 20,000 trees. For one arbitration, to offset the carbon emissions, you have to plant 20,000 trees. That is only one arbitration. Imagine the scale of arbitrations that happen globally and imagine the court system. I'd really love for you to, if you go to the Campaign for Greener Arbitration, you will find the entire study there as well. So I think sustainability is the obvious one, the third one. And the last, but not the least, is efficiency. And when I talk about efficiency, I don't just mean speed. I also mean the return on investment. If you talk to a lot of, you've all done internships in law firms, and I'm sure you've done internships in in-house corporates as well. nobody wants to go to court. Trust me, I was a litigating lawyer. I worked with law firms before. Even I didn't like to go to court because it's such a waste of time. It's such complicated stuff. So we really need to bring in efficiencies when it comes to, what is your TAT for deciding a case? And I'm using a very business term here called TAT. But what is the amount of time you use to decide a case? What is the time, if you file, when get it listed, etc. So we really need to make a fundamental change. So those are the 4 principles I think that AI can really help in. And if we can do those 4 principles, I think we've got about 95% of what the justice system has to look like. So accessibility, inclusivity, sustainability, and efficiency. And we can leverage all of those as well. I want to come back to, so I think Rohan already spoke about, different use cases for AI. So I was going to cover that, but I'll skip that. One thing I do want to do as a request to the Law Commission team and Nalsar and others as well, is we really need to talk about some open standards. And I have been part of some working group set up by the government as well on this through the Nandan Nilekani committee. Can we really have some open standards for filing of cases for anything really? We're getting open standards in finance now. We're getting open standards across domains. But if you look at law, there is no open standards. There is no uniformity. And the worst part is there is no even movement or there is no push towards open standardization either. So if we can all collectively come together, I would really be grateful, because I think that will make a fundamental shift in terms of how really we can use AI. Today, we're working as WebNyai, we're working with Punjab Haryana High Court, we're working with TTSAT. But for me to do the work in Chandigarh versus to do the work in Telangana, it's a lot of additional work. And then to do it in Delhi or Allahabad, it is a completely different story. So if we really need solutions, which work at population scale like Aadhaar, like UPI, we really need some open standards. And I think if we don't start now, I don't know when we would start. Thank you so much, everybody.
Thank you very much, sir. We'll take the questions and email them to sir, if any. Please post them to the group. I thank Mr. Vishwam Jindal for the enriching talk and the call to the Law Commission and Nalsar to initiate the movement forward, and the critical points stressed about how we have to go sustainable even to practice. And I think with the CJS call about using iPads and such technology means in the courts, I think we are moving definitely towards certain goals in that area. We now have the final address of the chairperson of this session, Professor D.P. Verma Garu, who is a member of Law Commission of India.
किसको क्लिक करना है इसको? Yes. You give the first one. First one. Here we have to click which one? How to click? What? This is to click. This one. Okay. Distinguished resource persons of the dais, enlightened audience in this house. In this remark, I would like to confine to certain issues which have not been covered adequately in the present thematic session. Though all the presentations by the distinguished resource persons have been excellent, they have touched the technological perspectives, access to justice and the judicial institutions, ChatGPT, generative artificial intelligence, and in the end, some attempts have been made to touch upon the principles of justice. Here I must say that the topic which has been assigned for this thematic session is artificial intelligence and principles of justice and implications for justice and under bracket chat GPT, generative AI, and emerging trends. However, in my speech, I'm just escaping chat GPT, generative AI, or emerging trends, and I'm exclusively confining myself to the principles of justice. Here, I must say that it requires a jurisprudential understanding about the principle of justice. Perhaps we may say that there are different kinds of justice. These justice may be distributive justice, social justice, economic justice, political justice, or even the complete justice under Article 142 of the Constitution. But these are the different kinds of justice. Well, if we say that inclusivity, efficiency, and other things are the principles of justice, I may like to differ. These are not the principles of justice. These are certain expectations about the nature and character of justice, that it has to be effective, it has to be inclusive, it has to be sustainable, and other things. Therefore, in order to understand the principles of justice, I'm confining to identification of the principles of justice. We have been talking about artificial intelligence technology, but now I am talking about principles of justice. Principles of justice are the technology of justice. These are the principles of law. These are the techniques of law. Law has its own tools and techniques, and these tools and techniques are found in the norms, precepts, and the principles. Therefore, the most important thing is how to identify the principles of justice, which may be very well be applicable in artificial intelligence for our purpose and for the purpose of the enlightened audience here. Now, here, with regard to the principles of justice, I think I should confine only to adjudicatory justice, and in adjudicatory justice, I'm splitting it into two parts: equitable principles of equitable justice and the principles of codified justice. Well, here, to start with, by conversation, I must say that we have all heard about the principles of justice, equity, and good conscience under common law principles. Similarly, under the law of torts, we have the legal principle of ubi jus ibi remedium. Wherever there is justice, there has to be remedy. But if we look to artificial intelligence, and artificial intelligence operative in the judiciary may say that if there is no remedy available in the legal system, perhaps justice cannot be done. But the principle says that ubi jus ibi remedium, wherever there is a justice, there has to be remedy, and remedy is to be provided. If there was a need of rules relating to sexual harassment of women at the workplace, there was no law, and in Vishakha judgment, there was judicial lawmaking that this should be. Whether we can think of this kind of contribution by artificial intelligence or not. Now, coming to some other things, I'm just omitting some other slides. I'm coming directly to the principles of equitable justice. This is the principle. What is equitable justice? Equitable justice is discretionary moral judgment that is expected from the people in judiciary. And what is found in discretionary moral judgment? Importance is to be given to community values. Importance is to be given to the subjective features of the parties and other surrounding circumstances. These are very important things. Whereas it is a principle which is to be, it is the principle of justice which is to be applied by artificial intelligence, and it is expected that it should come about it. So far as this discretionary justice is to be thought of, it can be applicable in criminal justice system or even in appellate decision making at the time of giving bail and other thing, looking into community values, subjective features, as well as other surrounding circumstances, we can think of how a criminal justice, in criminal justice, this criminal justice, these principles can be applicable. Besides this, in equitable justice, in this principle, we are thinking of particularized, case-specific explanation. We cannot treat that all the cases will be treated in the same way, because facts of all the cases cannot be similar. There are some differences, and these differences are to be nuanced. These differences are to be tackled with in particularized and case-specific explanations. Well, at the same time, we are quite aware that there are all the possibilities of arbitrariness and bias in human decision making. We cannot avoid it. It may be possible, but only thing is that in the name of the exercise, a possibility of arbitrariness and bias in human decision making, we can say that the human decision making is not good, and we should come over to come over to some of the some other kind of principles to be applicable in artificial intelligence. The other principle is principle of codified justice. Codified justice is what the law is. There is difference between is law and ought law. There is proposition and ought proposition. What the law is and what law ought to be. And once we are thinking of principle of codified justice, we will be sticking to what law are existing in our society, what has been codified, and all the judicial decisions should go according to it. And in artificial intelligence, if we apply the principle of codified justice, then perhaps it will be at the cost of equitable justice. Whether we should leave equitable justice altogether and we should switch over directly to codified justice. The other thing is that in codified justice, there is no doubt that there is a standardization over discretion. And this is being given much more importance in the name that it will diminish arbitrariness and bias in the judicial system. And we can also think of that if this principle is applied, it will lead to efficiency, consistency, and transparency in the society. However, we can also find out that if it is machine learning based algorithmic justice, the first thing is there has to be desired outcome without explanation. If there is no explanation, it is only desired outcome, which is predetermined, but these are the facts, these are the laws, and these are the case laws, and on this basis, perhaps we can come to a particular kind of decision. It is true that if this principle of codified justice is applied, it will lead to quick resolution of large number of cases. It is true, and therefore it is to be welcomed. Second one, that it is a program to clear entire nation's caseload, and that's why it should be accepted to a great extent. However, the problem is there are certain matter of concern. The first, lack of explicit adjudication indicative of actual lack of explicit logical reasoning and conventional human explanation. Now here, there is an expectation of adjudication which is indicative of actual human decision making. How decision making are taking place. If the decisions are being given, people want, what are the basis of this decision? What are the explanations? And this is also very important because it is in the mind of all the litigants, it is in the minds of all the lawyers and the public in the society, what explanations are being provided by this. Suppose there is a judicial decision by such kind of artificial intelligence based on the principle of codified justice, these judicial opinions are likely to be challenged. That what are the basis? And this will open the space for another kind of difficulty and problems. The second one is nuanced blend of ambiguity and clarity. And it relates to the problem of interpretations. If there are certain ambiguities and there is need of clarity, there is need of nuanced blend. There is a need of judicial wisdom in dealing with all these issues, which is very much expected, and perhaps we should think of some kind of transparency and opacity. The other thing, the next one is the matter of concern. Perhaps someone say that there would be no redundancy of jobs for the lawyers and other things. But the point is that there will be alienation because of exclusive dominance of technical specialists. The courts will be filled up with the technical specialists, and the lawyers will say, what a role we have. Why should we go to the court of law? And what is the need of spending so much time in the law schools in getting such kind of education? Because after 10 years or 20 years or 30 years, the law courts will be filled with technical specialists, and the technical specialists will have more importance than the lawyer. And therefore, if I am a student of law, I will feel that in that kind of situation, why should we study law? Because if we do not get such kind of job, perhaps we should alienate from it. The next thing, in conclusion, I must say, both the principles of equitable justice and codified justice overlap each other. We have to understand, in the name of artificial intelligence, we cannot say the world has changed and we will directly switch over to codified justice and we will not consider equitable justice. Both principles have importance in the judicial making, where law has balanced all these virtues altogether. And this has been the job of law. And this is very important. Replacement of human judicial function can be possible and may be good in some adjudicatory works. We cannot say that it is altogether neglected, and we should not say. Since some adjudicatory works, it may be important, it should be given importance. This technology is to support human judges. And once we say it is to support human judges, it is not total replacement of the judges. What Pallavi had just mentioned about the illustration of Estonia, where in 2017, robot judges were introduced. In China, in internet smart courts have been established. It is true, they have been done. But the point is, from jurisprudential point of view, we have to think whether technology has to support or assist the judicial system, or it has to completely replace the judges and the others. Because there are three phases of the technological application in judicial system. The first one is supportive, where it has to support. The second one is first one is supportive. Second one is replacement. One is to be replaced by other. That is the second phase. And the third one is that these technological advancement will bring predictive analytics, which will disrupt the judgment or the form of justice in our society. Now, in the end, I have few things which needs serious consideration by all the legal scholars and the law students. If codified justice replaces or it gives way to equitable justice, is there any possibility of basic structured doctrine in the next, or this kind of system in the next 10 to 20 or 30 years? Can we expect this? And similarly, I have also mentioned about Vishakha judgment, judicial lawmaking. That is very important thing. And the third one thing is judicial creativity. And these are the three important things which must be clearly examined by all of us in the context of artificial intelligence. So far as the common law system, there are three major legal systems in the world. The one is common law system. The second one is civil law system. Common law system is based on principle of precedent, stare decisis, whereas civil law system is based clearly on codification. Perhaps we have switching over to common law system if the codified justice, principles of codified justice is to be introduced in our society. Therefore, what I have indicated earlier, that the virtues of codified justice and equitable justice have been very well balanced by law in our society, and that is the demand. And if this is done, then we will be doing justice with this theme and with this subject. With these words, I thank you very much.
I thank the learned address of the chairperson of this session, Professor D.P. Verma Garu, who is a member of Law Commission of India. This address has critically focused on the theme of the session, focusing on justice and connecting the multiple aspects of justice with AI. And we thank you, sir, for your crucial address on the thematic session. With the permission of the Honorable Chairperson, we can end this session to move to the valedictory address. Okay. Thank you very much, sir. We will now end with the session, with thematic session, and I invite Professor Anand Paliwal, Member Law Commission of India, to please deliver the valedictory address, sir.
But it was very good, very good. Okay, sir, we should go.
So, good evening to everybody, all the dignitaries present here, and dear students. From the morning, we all have been listening about the artificial intelligence, the developments, the challenges, the legal, the other ramifications. How this idea strike the Law Commission, that first I want to point out. At once a time when there was discussion that how the artificial intelligence is going to play the role, the dangers that the artificial intelligence laid down, in that there is a one danger, and that is unclear legal regulations. So the Law Commission, with the research consultants and all the members, we have a discussion, what are the legal regulations, how we can work on it. And we had a first conference in the Delhi, second in Jabalpur, and this is third in that series only. So how the law schools can play an important role, that is also very important, because in Argentina, what I am saying, even in Singapore, the artificial intelligence, how it should be regulated, there the law schools are playing a very active role. Means they are coming with its suggestions. You can see the Argentina, the Singapore, the role of the law schools in determining what are the possibles, means threat by the use of the artificial intelligence. You might have gone through the newspaper also, where in a game, how one of the girl feels that she has been sexually harassed. That was a game only, but she was mentally disturbed by that incident. Recently, what happened that the NMC in medical education, they introduced one form that because of the ghost faculty, the students are not getting the good medical education. So what to do for that? They introduced that there should be Aadhaar-based attendance system, ABAS, and it is mandatory for every private university that they should ensure that the good faculty is coming and delivering the lectures to the medical students. But after some months, a complaint came to the NMC, and they find out that a university which are showing a list of good faculties, the faculty didn't exist in that university. The faculties are working somewhere outside that states also. So when they inquired, they find out that what they have done is that they have made a silicon. With the help of silicon, they have made a thumb impression, and their universities are using the same. See, I'm simply pointing out that on the one side, the NMC come with a good idea that basis of Aadhaar-based ABAS system, we are going to ensure that the students are going to get the good lectures from the good medical, that are the lecturers. But how they come out with a solution, that is also a type of, requires attention. Ki how we have to counter that such, though we are introducing in morning also, I heard one example where a person, one of the speakers said that when a person comes after visiting that Tirupati temple, the face recognition was not done. So these are all the challenges, but we cannot ignore the artificial intelligence. We cannot say that we are not going to use it because there may be certain challenges in that. We all know that what happened to Kodak. At one time, it was ruling the whole. Means that photo reels, Kodak never think that one day they will be wiped out. They never thought about it because they didn't change themselves with that of the artificial, with that of the technological advancement. One example when I'm citing is from the movie Minority Report. I don't know whether you have watched that movie or not. In Minority Report, what is there? Ki how to ensure that the crimes are not committed in a city. So they made a movie with that. They identify some very pure minds and say that once an idea to commit a crime, when that enters in the mind, our system will just find out that this person is having an idea to commit a crime, or he has a sense of doing something wrong, and when he will be in the process of doing the same, we will nab him, and this way we will stop the persons from committing the crime. This is what I'm stating from that Minority Report movie. Then what happened that one of the officers, years back, his son was kidnapped and he was murdered. So every time when the officers sleep, that scene keeps on coming in his dreams, that how his son was kidnapped and murdered, and he has a sense of revenge for the same. He want that, who is that person? Let me know once that person, and I want to encounter that person. The person who in fact has kidnapped the son of that officer, he was always afraid that someday he might encounter me. So he keep on sending 1 or 2 photographs of his son with some another person. He keep on sending the other goods used by the son last time. And lastly, he sent a photograph of some other person, that this is the person who kidnapped your son and murdered. And when the officer think he was going to kill that person, he was nabbed because of that system. I am pointing out only for the sense that whatever was feeded in his mind, with the help of all that photographs, with the help of all that dresses and all that, the officer come to the conclusion that this was the person who has murdered my son, and therefore I am to kill him. And similarly is it with artificial intelligence. It is something that is full of data and data only. If you want that the system should identify an animal properly, then that data requires 1 lakh photographs of that particular animal. Else, what happened in 2015, that the Google 2015 or in the year 2006, they used to identify African persons as gorillas. And for that, Google has to later on apologize. Similarly, what happened, an experiment was done when artificial intelligence, how is it to be used for the legal cases, is uniform manner. The drugs was distributed among the Africans and among the white people. But the artificial intelligence, the system that was used, the Compass system, which was quoted earlier, he only pointed that these African Americans are the person who are the drug peddlers, and they are required to be punished and not the white ones. Why? Because there was the data that was fed was having a biasness. In China, they were saying that the robot system, but I don't believe, because what happened in China, they first said that for the domestic cases, what we'll do is that we'll implant one machine in the home, and that machine will, after 1 year, will tell that whether the fault is of the husband or of the wife. In diverse cases, we are going to use it. It's a hypothetical case that was cited in the China, how to use the AI for the legal proceedings. So a case of divorce was was there between a husband and a wife, and the wife alleges that the husband is very cruel, and the husband alleges that the wife is very cruel. She doesn't hear, she keeps on shouting. But once the machine was installed, as regularly the husband comes and argue, and the wife keep on slapping herself and say, no, sorry, excuse me, sorry, I will not do, I will not do. So husband thinks that how my wife has changed because of this machine. She now never argues, but she keep on slapping herself and say, sorry, I will not repeat, I will not repeat. But what after 1 month, what the machine delivers, machine say that this is 100% fault of the husband. He is very cruel. He used to slap his wife, and wife keeps on weeping and saying, I am sorry, I am sorry. So what I am saying is only on the basis of the data, the cases can be decided. It can never be. But I am very much optimist. I am very much optimist in the way that there will never be any such situation when the law or the law professionals, they feel that they are being dominated by any technological advancement, because technology will always be there to assist the lawyers. Because I have that type of feeling that lawyers and the persons who are in the law field, they are always above the other. In a lighter note, I am saying it's a joke only. What happens that a father, he says that he has 3 sons. He say, one son say, father, I want to become a doctor. Okay, I will ensure that you get the best medical education, you will become the doctor. Second say, I want to become a very big engineer. Okay, I will ensure that you get the good engineering education and you become the engineer. Third, father, I want to become a lawyer. Okay, I will ensure that you get the best legal education. Then what? But father put a condition that at my death, what you all have to do, you have to put $10,000 in my coffin at the time of my death, when you come to pay last regards to me. So at the time of the death, the doctor, the son who become the doctor, he comes, he pays his last regards and put $10,000 in the pocket of the father in the coffin. Engineer, he too comes and again he put $10,000 in the coffin of the father and he pays last regards. Then comes the lawyers and advocate. He took that $20,000 from the coffin, put the same in his pocket and placed a check of $30,000 in the father's coffin pocket and say, father, whenever you want to realize this, you can get it honored. And this is my last regard. So what I personally believe is that then the person who are lawyers, they know how the technology is going to be used, and they are not going to be dominated by the technology. And lot of questions has been raised that yes, there may be the question that about the responsibility and accountability. When we are talking about the artificial intelligence, obviously the question will come that who will be held responsible? The one who is using the technology, because he has relied on whatever has been said about the technology. That's why he used it for the legal proceedings. Or the one who has created that, who has manufactured that, who will be held responsible. So in that cases, even if the artificial intelligence is going to be used in the legal courses, then also the role of the legal lawyers are there to ensure that how the judgment has been arrived by the machine, how the algorithms has been used. And we have been technological friendly. What in the first session, what our law commission member was saying that previously what happened, that the juniors, that the lawyers, they come to the court with the diaries. They are holding the diaries. But now every lawyer, even the junior, they're having tabs. And they are so technological friendly that they know how to cite the cases, how to put the data and all that. So AI will also be there to assist you in the speedy disposal of the cases, in identifying, in listing, in finding out. The search engines all will be there. And therefore the AI should always be used as a mechanism to assist us for the speedy disposal of the cases. We are here in the very noble profession. We have a empathy that the machines cannot have. We have a sense of responsibility towards a client, what the data cannot ensure. When we wear the gown, you know that always a small pocket is there. What's the reason behind that? in the previous session, there was a talk regarding the justice. How the legal, in the 80s, there was a talk that a person should have access to the legal recourse. But the same definition changed in the year 95, 96 onward. No, it should not be to ensure to legal recourse, to ensure to legal education should not be there, to ensure to justice education should be there. It changed, and therefore these all moot courts, these all other procedural part was introduced there to make you update with that version. Ensuring the delivery of justice is more important than ensuring to have access to the legal recourse. No access to legal recourse, no, it is enough. Now you have to ensure that access to justice is being done. And therefore, when the person who is a noble profession, such as a lawyer, when he wears that black gown, the idea behind was there that the lawyer never fight for the money. He fight for ensuring that the justice is delivered. And whatever the capacity of the client is there, he put the amount in the back of that pocket, which was behind the gown. So the advocate, he never asked for the money. He fight for the ensuring the delivery of the justice, and whatever is the capacity of that client, he used to pay the same to the advocate. So we are there in that profession, which ensures that the justice be served. So when we talk of the technological advancement, I think that we will be more, with the help of this technology, with the help of all these legal education, technological education, we will be in a position to serve the justice in a better manner. And with my concluding words, what I want to say is that what, as a law student in the area, when you will be there in the field of this your legal profession, then certainly there will be some more challenges. There will be certain type of more I should say more hard work will be required. Besides being a legal education, you should be also aware about the technological advancement. That is all what is expected from you. But how we have to ensure, main thing is that at every step you should ensure that the affordability of your for providing the justice should always be there. There is one example that I heard from one of the learned justice. He says that I always, during when I was there in practice, I be there as a Indian Railways. Indian Railways, in the sense, he say, for ensuring that every person reaches the destination, there is a provision for the sleeper class, first class, second AC, third AC, every person according to his capacity, but the railways ensure that the person reaches to the destination. So here also, as a law student, in your future, you should have affordability in the sense that every person can approach you for ensuring that he gets the justice. And this technological advancement, this AI, all what have been coming will always be there. That is not going to replace us. That will be there to assist us. And how we have to use that artificial intelligence, it is all up to us. So I am not going for repeating the same, but wishing you all the best. And we all expect that with the help of the artificial intelligence in the years to come, we'll see a remarkable change in the legal era, in the justice delivery system, and we all be a part of it. Thank you.
I thank Professor Anand Paliwal for the wonderful valedictory address, upholding and reminding us, all the young law students here, of the noble profession of law and how we have a fundamental duty to make sure, like Indian Railways, to make sure that justice goes to all. And as Nalsar University actively engages in various legal aid and other social justice improvements, we hope that in the coming years, as we integrate law with the honorable learned message from the Law Commission and other legal fraternity, we'll make sure that legal justice, Nalsar University, able to deliver to all the people we are catering to right now in a much diverse manner. Thank you very much, sir, for your address. To conclude the session and give a synopsis and a way forward and a vote of thanks, I invite Dr. Krishna Ravi Srinivas, sir, to deliver the address. Thank you.
Good evening, everyone. We are in the fag end of the day, and then we had a long day, very interesting discussions, very thought-provoking ideas and all. So it's my honor to provide the synopsis based on the reporter's records, and then also to suggest a way forward. We began the day with the welcome address of VC, in which he also highlighted many of the issues as well as the way forward. So I will begin with the first session, not the first, but with the remarks made by Srimati Ramadevi Lanka, Director Emerging Technologies, Government of Telangana. Srimati Ramadevi Lanka discussed Telangana's leadership in AI law, highlighting its potential to streamline legal process, assist in sectors like agriculture and juvenile justice, and reduce case backlogs. She also warned of AI's risks such as hallucination and deepfakes, but underscored its promise in addressing the delayed and denied justice. I mean, this is the common refrain which you have been seeing throughout the day, people underscoring both the promise as well as the negative impacts or cautioning against some of the things like hallucination. Dr. Rita Vashishta, Member Secretary, Law Commission of India, highlighted that Hyderabad's dual role as a historical legal hub and its growing technological prowess. She emphasized the importance of fully integrating AI into sectors like healthcare, agriculture, and law, where it can revolutionize processes such as legal research, decision-making, and access justice. However, she also cautioned against the risks of AI, including biases and deepfake technology, stressing the need for ethical frameworks to guide AI's integration to judicial system. Dr. B.V. Mohan Reddy, Chairman of NASCAM, former Chairman of NASCAM, gave a special address in which he highlighted the rapid advancement of technology and their impact on law and governance, emphasizing the need for robust legal frameworks to address challenges like data privacy and AI ethics. He also shared a lot of his insights based on his decades and decades of experience in dealing with technology, particularly his earlier experiences with the computers. He advocated a multidisciplinary education and continuous learning to keep pace with these challenges. In the session one, we had the first speaker, Dr. M. Karnanidhi, part-time member of the Law Commission of India. He emphasized that while technology has greatly simplified legal process, the role of the judge rooted in human rationality cannot be replaced by AI. He in fact questioned whether AI could ever match the depth of the human judgment, particularly in complex legal matters like evidence appreciation. Although AI can assist in tasks such as case identification and investigation, it cannot replace the human element in judicial decision-making, as in cases like Akiran Gopal in Madras High Court. The challenge lies, according to him, is in determining the extent to which AI can be integrated without compromising the essence of human judgment. So he rather cautioned us that we should not overemphasize technology at the cost of human judgment. Dr. Kanandaru again highlighted EE's works with companies to addressing EE's evolving landscape of regulation, particularly focusing on public safety, privacy, and AI admissible evidence in courts. Technological advances such as cloud computing have enhanced AI, but the legal tech startups often get overlooked. And the differences between narrow AI and potential AI was also pointed out here, but informing us that large language models impacting the legal industry significantly. She also highlighted that while AI will replace some jobs, it will also create new opportunities, underscoring the need to enhance AI for better access to justice and social progress. She had many things to say, but then since we didn't have time, she simply summarized some of her major points. What is important, we think, is that the way she emphasized upon the EU's approach towards some of the issues like privacy and also regulation of technology. Dr. Daniel Matthew, Associate Professor, National Law University, Delhi, attended online. He pointed out that the 2019 World Access Report showed that access justice has worsened, partially on account of the wealth-based disparities. So AI is now used in judiciary to improve accessibility and to speed up process, with large firms leading and smaller ones following. On the other hand, in India, AI has been used in court decisions and research, but concerns about AI, hallucinations, bias, and loss of human empathy remain. So according to him, to address these things, transparency, trust building, and regular audits are crucial. So he again emphasizes that we need to strike a balance and we should not be overawed by technology, and more importantly, access to justice is more important as we rely more on technology. Mr. T. Venkateshwara, Registrar of Telangana High Court, pointed out that the High Court itself has gone significant and tremendous technical advances since the 1980s, starting with the exploration of the key modernization in the late 1980s, and then the Supreme Court Committee in 2005 providing laptops, internet training. Then 2018, there was a development of software and creation of a unified case management system. Then the recent innovations, including a comprehensive website that was launched, proceedings being streamed on live, e-filing was introduced, and court records dating back to 1950s were digitized. In 2019, including as well as a translation tool for legal documents, adoption of new systems for information sharing, and speech technology, text technology have been installed. These advancements aim to modernize the judiciary, enhance transparency, and improve access to justice for the people of Telangana. He, in fact, gave us a quick synopsis of the technological transformation in the judiciary and then judicial lawmaking, as well as how the earlier they were all laying upon the printing process and what sort of issues they faced while doing some of the administrative work in the High Court. Dr. Akansha Natani, in fact, also used some case studies to highlight some of the biases and issues and invoke questions among the legal fraternity. She gave case studies relating to job recruitment biases in AI-based job recruitment, digital apartheid, which is often happening in South Africa on account of the CCTV systems that created racial monitoring issues. Again, the potential harm and potential for misuse. Then the local issues like where in Tirupati, the AI failed to recognize a driver due to shaved head, affecting his livelihood and revealing systematic biases. She also pointed out that the Samagra Vidhi, the program for citizen profiling, faced scrutiny over data privacy and RTA concerns, showing challenges in balancing technology and legal rights. And in the case of global perspectives, she pointed out that data ownership regulation varies from jurisdiction to jurisdiction. Particularly in EU, data belongs to individuals, while in China, it's a state control affecting privacy and legal frameworks. Again, there's a huge disparity between the North and South in impact of AI, because in the global North, structural dependencies in environmental concerns are often overlooked. The world's data centers pose significant environmental challenges, particularly in terms of resource use like water use. Then there are many legal and ethical considerations, including the right to explanation. For example, algorithms must explain decisions requiring robust legal frameworks, and AI development must focus on quality data sets, diversity, and human oversight. Again, fundamentally, the whole question is also the nature of AI. AI's nature integration needs consideration, balancing its capabilities with ethical and legal safeguards. The session 2, since we could not have Mr. Srinivasa Garu as he could not attend it, he sent us a note which was read, in which the point was this: AI can greatly improve the efficiency of the legal services by streamlining research, enhancing contract analysis, and reducing the cost while improving the client experience. However, its integration raises ethical concerns about algorithmic bias, transparency, procedural fairness, and addressing these challenges through robust oversight and regulatory frameworks is very important to ensure AI supports justice without compromising ethical standards. Dr. Vidya Shankar in his presentation talked about how AI is transforming India's legal sector, particularly in addressing the delays in the judicial system. He underscored the fact that while AI can improve efficiency and fairness, its role in decision-making raises lots of ethical concerns, particularly tools like chatbots and translation software while they enhance justice. But at the same time, there are a lot of concerns relating to privacy, and the need for thorough testing of the software and applications remains. Sorry. And he also said that if carefully implemented, AI can boost efficiency and accountability while upholding justice. Mr. Rohan K. George gave us a very provocative talk discussing about the impact of ChatGPT and how we are using ChatGPT and its impacts on students' experiences with them. He said, we all have faced certain issues with ChatGPT during internships while making projects, etc. This reflects the broader trend where AI excels in certain aspects like drafting, but fails miserably when it comes to research accuracy. So this parallels the parallel technological disruption in law, like the MS Word replacing secretarial pools of the earlier years, and then the online legal databases transforming legal research. So according to today, AI tools are emerging at a similar inflection point with applications in contract drafting, privacy compliance, and due diligence. However, he also pointed that issues like AI hallucinations, privacy concerns, job redundancy highlight the need for careful and informed use of AI, particularly in legal applications. Ms. Pallavi Sondi, who joined us online, mentioned that her experience with ChatGPT to draft a license agreement oversight, highlighting AI's roles in making legal tasks more efficient, but emphasizing the need for rigorous review. She pointed out that AI's potential to issues in the justice system such as case management, e-filing, automating registries, and all. At the same time, AI could also assist with judicial vacancies, predict litigation outcomes, and even serve as a robo judges, as in Estonia. However, the challenges like privacy, information security, and transparency still persist. She also pointed out that public-private partnerships and AI-driven translation services could advance AI integration into the traditional legal system. Mr. Vishwan Sindel emphasized the potential of AI and the technology to address backlogs in justice system, highlighting the Bill Gates view that AI should be used to dispense justice. He outlined 4 principles for AI in justice: increasing accessibility to courts and legal advice, making AI systems more inclusive, ensuring sustainability by reducing resource use, and improving efficiency in legal processes. He also called upon open standards in legal tech for better serve a large population, and also to ensure that the lawyers across the countries are able to stick to single standard by this. Professor D.P. Verma, member of the Law Commission, gave his valuable thoughts, and then he distinguished between principles of justice and expectations like inclusivity and accessibility, while emphasized on the importance of the adjudicatory principle. He highlighted the balance between equitable justice, which is discretionary and values community input, and codified justice, which on the other hand ensures efficiency and transparency and consistency. So he warned against over-reliance on AI, stressing on that technology should support rather than replace judicial functions while maintaining virtues of both codifiable and equitable justice in society. Professor Anand Paliwal highlighted the need how we can use AI and also cautioned against some of the ways AI can go wrong. In fact, he almost gave a good synopsis of all the previous speakers' talks also. I thank all the speakers and then the chairman for giving enormous inputs and also highlighting both the positive as well as negative aspects. But one thing which is striking among all the presentations, talks, and the discussions which we had today is that people are very well aware of the positive and negative aspects. And more importantly, it's also a significant fact that there's a consensus that there is no way except that we need to use AI. But the challenge before us is how do we use AI? And more importantly, there are a lot of technical issues ranging from open standards to how do we modernize in the way that we again stick to fairness principles, equality of opportunity, and constitutional values. More importantly, there is a very clear-cut view that technology should be relied upon, but it should not override judicial processes. It should not override legal rules and the human element in judgment making. So I think the way forward is to take these insights, valuable insights, into account and then develop a lot of things like training materials, develop software which take these things into account, also develop programs and courses, and more importantly, we need a lot of research. For example, in the right now, we have a lot of examples from abroad. We also have a lot of case studies from abroad, and particularly in the literature, we find a lot of philosophical discussion, legal principle discussion happens mostly from the West. And here I think we need to really do a lot of work where law schools like Nalsar can really play a major role. So I think the way forward lies in very simple thing that there is a broad consensus on the use of AI that it is inevitable, but we should do it with greater caution. And as lawyers and legal scholars and legal academics, we have the greatest role in doing this. And with the help of judiciary and judicial administrations, we can certainly take this journey of using AI in a responsible and ethical way forward. So I think this is the way forward in which we all have a role. And thank once again all of you, and thank the speakers, the chairpersons, and everyone for making it possible. I thank Vice Chancellor for his encouraging support, and then for all the advice and guidance which he had given. I thank the administrative staff and everyone who had helped with us in making this possible. In particular, this event was organized in a short notice, and then we could not invite many of the judges because they were all on a training program. And since we tried our best to invite some of them, it couldn't happen. At the same time, we also ensured that it was telecast online so that people could watch it. So I thank you all once again, and I wish you all, I hope that all of you benefited from this, and we look forward to continuous interaction with you. Unfortunately, we couldn't have discussion sessions on account of the lack of time. But I'm sure that what you could do, you could send us your questions, which we will in turn take up with the speakers, or we will come up with a reported summary, and then we will also have the list the questions, get the answers, and attach to that. Thank you all. Thank you. Yeah. So we'll break for the tea. The event is over. Thank you all. Thank you.